Delivery of order, item number 1.
For reasons mentioned in the order, this court is of considered opinion that the jurisdiction of this court under Article 227 of the Constitution of India to examine the issues raised in this revision petition is not outstayed, and therefore the objection raised by respondent number 1 regarding the maintainability of instant civil revision petition is rejected. Let the matter be listed again on 12th of February 2026 for hearing. The respondent number 1 may file additional affidavit in opposition if he desired to do so before the next date fixed, with a copy of the same to be furnished on the other sides in advance. The petitioner shall also take fresh steps with regard to issuance of notice on respondent number 6 and 8 by speed post as well as by usual mode before the said date. List accordingly.
Much obliged, Lord.
Obliged.
Item 2.
File. No, both file. Both. For reasons mentioned in the order, you have to see the order in evening. It has the orders. This interlocutory application is allowed. The respondent number 3 bank is directed to immediately revert the 861918 numbers of equity shares from DPID number 300476 to DPID number 301151. List this matter on 12th as fixed earlier.
Grateful, Madam.
Obliged, Madam.
Ito ay discuss. Ito na. This I will be discussed. 3983. One of the. Yes.
Wait, please, Your Lordship. One of the concern for the other side, may I pray item number 12 be kindly adjourned and fixed sometime in the month of February, preferably 11th, 12th. I'm for the other side,
Item number
12.
heard Mr. S. Bernick, learned counsel for the respondent, who prays for an adjournment on
2
the
weeks.
ground of personal difficulty.
No, we have to file a response to that,
Response to
the revision petition, my lord.
on the ground that the respondent intends to file a written objection against the petition filed by the petitioner. He submits that he has informed learned counsel for the petitioner regarding his prayer for an adjournment, who has no objection to the same. Hence, the prayer is allowed. Let this matter be listed on
25th, I had sought consent from sometime earlier. 2 weeks I had sought actually.
12th of February.
Yes. Obliged, Lordship.
May it please your lordship, my lord. My lord, IA has been filed for minor correction of the order, my lord, passed by this honorable court. My lord. I am waiting for listing on my lord next week, my lord.
Next week,
Next week, my lord, on my lord,
order passed by me,
yes, ma'am.
typographical order.
Typographical.
When have you filed?
I have filed my lord on
Tomorrow.
obliged, my lord.
February, Lordship. Consent taken of the right Lordship. I beg to mention item number 9, Lordship. Lordship,
Mm.
matter-
9,
Lordship,
yes.
matter will be taken up on 23rd February, Lordship. Today some parts.
What is your name?
Lordship?
I am for the petition.
You have any objection? Heard Mr. B. Deori, learned counsel for the respondent number 5, 6, and 7, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. A. Deka, learned counsel for the petitioner, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed on 23rd February. The interim order shall continue till next day.
Lordship, back to mention item number 43, my lord. Consider the other, my lord. Lordship, matter may possible for the day, my lord.
Item numbers
40. 43, I am appearing for the respondent. Hearing matter.
Yes. What is your name?
Hussain.
Heard Mr. A. Hussain, learned counsel for the appellant.
Yes, my lord.
Appellant. Appellant, who prays for an adjournment. Also heard Mr. S. Deka, learned counsel for respondent, who does not raise any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed on 5th of March.
5th March, Lord. God bless you.
May I please your lordship, with the consent of others, I beg to mention item number 33. In this case, we need some time to file our objection.
What is your name?
R.K. Mohanto.
Heard Mr. R.K. Mohanto, learned counsel for the respondent, who prays for some time for filing written objection against the application, interlocutory application filed by the applicant. He submits that he has informed the learned counsel for the petitioner regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed on 13th of February.
Oblige.
May please your lordship. I beg.
You are present. What is your name?
Miss PP Das Lordship, for the respondent Lordship.
He was for,
This for the petitioner, I think Lordship.
he was for respondent in I. Also heard Miss P.P. Das, learned counsel for the other party, who does not raise any objection. Yes,
May please your lordship, I beg to mention item number 17. Lordship, this case has
17,
17.
yes.
This case has become infructuous as the title suit in concern whose order we were challenging has been dismissed for default. The
What
case-
is your name?
I Bhattacharya, Lordship,
You are for?
for the petitioner. I'm
You-
appearing
you-
on behalf of P. Deka, Lordship.
You want this to be dismissed?
Yes, your lordship.
Heard Mr. I. Bhattacharya, learned counsel appearing on behalf of Mr. P. Deka, learned counsel for the petitioner, who submits that as the connected title suit pending before the trial court has been dismissed for default, this CRP within bracket IO has become infructuous. Stop. Considering the submissions made by learned counsel for the petitioner, this CRPIO is dismissed on becoming infructuous.
May please your lordship. Lordship, with the concern of the other side, I beg to mention item 24, lordship. And for the appellant in this case, we need 1 week time to file our affidavit for paper publication.
24.
24, lordship.
Heard Mr. S.P. Sharma, learned counsel for the petitioner, who prays for some more time for filing affidavit in compliance regarding paper publication of the notice to respondents. He submits that he has informed learned counsel for the other side regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed
After 1 week.
on 13th of February.
Obliged. May I please your lordship? Beg to mention item number 11 also. I'm for the petitioner lordship.
For Lordship
Yes.
and for the respondent.
Yes.
So with the consent of the other side lordship, we beg to, we pray for adjournment the matter loss.
What is the ground?
Because of the personal difficulty, he is not well.
What is your name?
The conducting advocate is not well.
What is your name?
Me, Prosenjit Medhi, Lordship.
Heard Mr. P. Medhi, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. Also heard Ms.
M. Tiwari.
M. Tiwari, learned counsel for the respondent, who does not have any objection to the said prayer. Hence, the prayer is allowed. Let the
Interim
matter,
maybe.
let the matter be listed on 13th of February.
30.
The interim order shall continue till next day.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 13.
1-3,
13.
yes. What is your prayer?
Lordship, I beg to adjourn the matter for today. My senior counsel has some personal difficulty.
What is your name?
S. Arafat.
Heard Mr. S. Arafat, learned counsel for the appellant, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. The prayer is allowed.
18th of February.
Let this matter be listed on 18th of February.
Obliged.
Motion, item 3.
Maybe the Lordship. Lordship, this matter pertains to transfer of FC Civil 1360/2025 from Family Court to Kamrup to Honorable District Judge Bongaigaon, Lordship. As the ground is that the wife is unable to travel from Bongaigaon to Guwahati, as he has a small kid of 3 years, and moreover, the parents of the petitioner is very aged, who is unable for her to take some.
What is your name?
R. Shah.
Heard Ms. R. Saha, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Srimati Pooja Basfor, praying for transfer of FC within bracket civil case number 1360/2025 pending before the Court of Learned Principal Judge, Family Court number 2, Kamrup Metro, to the Court of District Judge, Bongaigaon. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 20 February.
Proceeding may be stayed.
At what stage it is pending?
Uh,
You have not checked.
Checked.
Therefore, I am not staying now. You come next time after checking it. Next date is 20 February.
Item 4.
May it please your lordships. Lordship, this is also a transfer petition under section 26(3) of Code of Civil Procedure for transferring FC Civil case number 169 of 2025, which is pending before the Court of Learned Principal Judge, Family Court, Kachar. And the petitioner is staying in Guwahati with a minor daughter of 7 years old, and it is very difficult for her to leave her child in Guwahati and travel all the way to
Okay.
Silchar for the matter.
Heard Ms. Pooja Agarwal, Learned Legal Aid Counsel.
Yes, Lordship.
Learned Legal Aid Counsel appearing on behalf for the petitioner. This transfer application has been filed under section 26/3.
Yes, Lord.
What is there in 20?
Lordship, it categorically provides that if it is within the jurisdiction.
Why it is not under 24? wrong quoting of provisions. It ought to have been 24.
Understand,
You rectified that
Lordship.
under section 24 of the Code of Civil Procedure 1908 for transfer of FCs within bracket civil case number 169/2025 from the Court of London Principal Judge Family Court Kachar to the Court of Principal Judge Family Court at Kamrup Metro, Guwahati. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 23rd of
Lordship, could it be? Could it be on 20th, Lordship?
20th of February.
Lordship, there is a prayer for interim.
What stage the suit is pending?
Lordship, the evidence is just about to start.
You have already appeared there.
Yes, Lordship.
Stop. Considering the grounds taken by the petitioner in the instant criminal petition praying for transfer of the aforesaid case, further proceeding of the FC Civil case number 169/2025 pending before the Court of London Principal Judge Family Court Kachar shall remain stayed till next returnable date.
Lordship. Lordship, and for item number 3, Lordship, I apologize for interrupting between the court, Lordship. The next date of this FC Civil 1360 is 10/2 for written statement, Lordship.
It's a mistake of the considering the ground stated in the item number 3, further proceeding of so and so cases shall remain stayed till next day.
Item 5.
Lordship, madam, you pass over the time.
Why?
My senior was.
We are issuing notice.
No, Lordship, we also need to stay, Lordship, because another transfer petition, Lordship, already pending before this honorable court, Lordship.
Okay, after some time.
Item 6.
May it please your lordship. This is also transfer petition, my lord. I am praying for transfer of money suit number 6 of 24 from the Honorable Court of Civil Judge Senior Division Udalguri to Civil Court Senior Division Mangalore.
On what ground?
On the ground that, my lord, the Civil Judge Senior Division Udalguri has no jurisdiction to try the matter, my lord. The fact of the case is that, my lord, as stated in the plaint by the respondent, my lord, that they want to recover a part of the agreed payment, my lord, which has been entered into an agreement at Mangalore, my lord, in the year 2015, my lord. He claimed that for payment of certain amount of rupees 25 lakh.
At what stage this suit is pending now?
My lord, pending before the Civil Judge Senior Division Udalguri.
At what stage?
Stage is the cross of PWs, my lord.
You are appearing?
Yes, my lord, I
Okay, we are issuing notice. Heard Mr. What is your name?
am sorry.
M. Soikia, Learned Counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioners for transfer of money suit number 6/2024 pending before the Court of London Civil Judge Senior Division Udalguri to the Court of London Civil Judge Senior Division Mangalore. Issue notice to the respondents. The petitioners shall take steps for issuing. The petitioners, single petitioner is there.
Petitioner.
The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 23rd of February.
May I prefer stay the further proceeding at this stage, my lord?
Mhm.
My lord, otherwise they have transfer of
No stay.
liability.
Item 7.
May please your lordship. My lord, this application has been filed praying for transfer of FCC civil case number 1451 of 2025 from the Court of Family Court number 2, Kamrup Metro, my lord, to the district judge, my lord, Sojali. Mainly on the ground of lack of jurisdiction, my lord, and hardship of the petitioner, my lord.
Why lack of jurisdiction?
Because, my lord, the petitioner is residing at Borhaderi in the district of Bozali and
Where the marriage was performed
at my lord Borhaderi and
and where you lived together,
my lord in the district of my lord Nolbari, Khelwa, village Khelwa, my lord.
you never resided
No,
in
my lord.
Guwahati?
Never, my lord.
Okay. Heard Mr. UK Das, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Srimati Minu Roy, praying for transfer of FC Civil Case number 1451/2025 pending before the Court of Learned Principal Judge Family Court number 2 to the Court of Learned District Judge Bojali. The Learned Counsel for the petitioner submits that the Principal Judge Family Court does not have jurisdiction to entertain the divorce case filed by the respondent, as neither the petitioner ever stayed in Guwahati with the respondent nor their marriage was performed in Guwahati. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 23rd February. Stop. Considering the grounds taken by the petitioner in her transfer application, the further proceeding of FC Civil Case number 1451 2000/2025 pending before the Court of Learned Principal Judge Family Court number 2, Kamrup Metro and Guwahati shall remain stayed till next returnable date.
Binding item 5.
May I please lordship? My lord, here, my lord, the petitioner husband is praying for transfer of family case, my lord, dispute case, page 300.
What is this case?
My lord,
Eh.
case is for divorce, my lord.
Wife has filed.
Yes, my lord, it is recently filed, my lord, 2025.
Where it has been filed?
Family court, Kachar at Silchar. My lord, background of this case is that my lord, she filed another case, my lord, and which is stayed by the Honorable Court. This is, my lord, page 25. She filed, my lord, 1 DB, page 25. Miss DB Act case number 05/2025. It is filed before the Subdivisional Judicial Magistrate, Lakhipur. And this Honorable Court stayed this proceeding recently. This stay order is page 61. Madam. Proceeding of so and so case is next week. This case is also, my lord, fixed today, my lord.
No, why you want? What is your
He-
ground for?
They are local people, my lord. He is from my lord Rathabadi, Koringon, which is a remote place, my lord. And Silchar, one case filed at Silchar, another my lord Lakhimpur. This is almost my lord 75 to 80 kilometers away, my lord, from Rathabadi. He has to come first Koringon, my lord 40 kilometers, then Koringon to Silchar. More than 80 kilometers. This is one aspect. Another aspect, my lord, she has, my lord, some, my lord, people who are, my lord, threatening their,
Where?
at her native place, my lord.
Where is the native place? Native place is Lakhimpur.
Lakhimpur, my lord.
Case has been filed in Kachar.
Acha, Silchar,
Lakhimpur is at a distance.
20, 25 kilometers.
That logic is not applicable to this case. We are issuing notice. Heard Mr. A. M. Barbhaiya, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Maqbool Ali, praying for transferring of the FC within bracket civil case number 315/2025 from the court of Learned Principal Judge Family Court Kachar to the court of District Judge Sri Bhumi or to any other court having jurisdiction. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD, by speed post, as well as by usual mode within 7 days from the date of this order, returnable on 24th February.
This matter may be listed along with that matter.
No,
Because, my lord, both the case, my lord, wherever is tried in the same court, it would be better, my lord. I am praying, my lord, at my cost, my lord, at a convenient neutral place. So therefore, both the case may be tried in the same place.
no, this case has to be tried before the court of
Yes.
family court or district judge.
Yes, my lord.
Other case is a magistrate tribal case. It
Here-
can be tried
here,
before.
Your lordship is not granted stay.
No,
We will contest, my lord. But that case, both the case may be, my lord.
that case is not before me now. You pray before, when that case is listed on 24th February.
Admission.
Deep, your lord.
A.
Yeah, please, my lord, in this case, I am appearing for the respondent number 8. In my senior will appear, my lord. He has some difficulty today. May I pray that lordship may take up this matter on Friday, my lord.
No, Friday it will be difficult.
My part may,
For first week of February, May, you choose a date.
Monday.
no, not first. Then, my lord.
First or second week of February.
Sixth of, my lord.
February,
6th of February.
okay.
Oh, sorry, it is just a minute, my lord. हमारा ninth. Huh? Second की है second or third होगा जी? Huh?
Second or third?
This is a very old pending case.
All pending matter, my lord. Recently, I have seen the order status from there. It was for plaintiff's evidence. Because, and thereafter it has been transferred to the, my lord, commercial court. Recently in, my lord, 22nd of,
December.
22nd of December.
No stay is there. Any stay is there?
No stay. Plaintiff's evidence is there, prior to that. Then it has been transferred on 22nd, my lord. The next date is not yet come, my lord. It will be, my lord.
Okay, when can we fix it? Heard Mr. K. Agarwal.
It can be disposed of at the admission stage itself, my lord, my prayer will be. And if your lordship can take I can argue today, my lord.
No, in part it will be difficult. Assisted by Miss, what is your name? Assisted by Miss P. Neog, learned counsel for the petitioner. Also heard Mr. A. K. Gupta.
For respondent number 8, my lord.
Appearing for respondent number 8, who prays for an adjournment
2nd of March.
on the ground of personal difficulty of the conducting counsel for the respondent.
6th of March.
6th of
Let this matter be listed when?
6th of March, my lord, because his wife is
6th
pregnant,
of-
his senior will not be away from 5th,
Okay,
6th of year.
okay. Let this matter be listed again on 6th of March.
Oblige.
6th March.
Item 10.
May it please your lordship. Lordship, as per the office note, the notice issued to the respondent has not been served. So I may be allowed to bring on record the alternate address, your lordship.
Alternate. How many respondents are there?
There is only one respondent. Because I just spoke with the petitioner. He informed me that there might be some other place he has shifted because he's a railway employee. He was previously posted at Rangia.
No, there is no service report.
Service report, in the office note, it is written. Addressee.
No such address, yes. Now, what is your prayer?
I may be allowed to bring on record an alternate and correct address of the respondent.
Okay. Heard, Mr. What is your name?
G.R. Datta,
G.R. Datta, Learned Counsel for the
petitioner.
appellant. On perusal of the office note, it appears that office note dated 21/2026. It appears that the notice sent to the respondent through Speed Post has returned without service with an endorsement within inverted comma, no such addressee. Return, no such address, return to the sender. Stop. In view of the aforesaid office note, Learned Counsel for the appellant has prayed for some time, prayed for allowing the petitioner to find out an alternate and proper address of the respondent so that notices may be sent to at the proper address. The prayer is allowed. Let this matter be listed
2 weeks.
24.
on 24th February.
Deeply obliged.
Item 14. Item number 14.
None has appeared for appellant on call. Let this matter be listed again on 13th of February.
Item 15.
Yes.
My lord, I have framed the substantive question of law at page 3.
Okay, what has happened? What is your case?
My case that I am the occupancy tenant, my lord, in respect of the let. And accordingly, the decree has been passed. First of all, my lord, what the learned trial court,
You are against the
appellate court.
appellate
Appellate
court's
court.
dismissal of your counterclaim.
Yeah, counterclaim as well as allowing the appeal of the plaintiff. My lord, so far that case, that aspect is concerned, my lord. So far the counterclaim is concerned, a separate appeal has to be filed. In this particular case, no separate appeal has been filed. And for that particular purpose, my lord, may I take a look
Okay. Okay, that is okay. Law is clear.
that there must be the appeal. And if there's no appeal, in that case, that attains the finality, my lord. And it cannot be dismissed. So that, my lord, in my view, the ground number 1, 2, and 4 are the substantial questions of law. And moreover, the Khatian was granted in my favor and that was not believed by the appellate court. So it is the conclusive proof of my title as occupant tenant, my lord.
Ground number 1 is a general question.
General,
That
it
that
is
cannot
not
be a
more-
substantial question of.
It is also, sir, reversing is also a substantial question of law. But in that case, my lord, 2, 3, and 4, your lordship may.
That whether the appellate court can reverse the decree passed in counterclaim without there being any appeal against the same.
Yes.
What is the law?
Law is very clear, my lord. So far the counterclaim is concerned, there must be a separate appeal.
Where is the law?
The law for that one, this matter has already been decided by our honorable court, my lord. And I also filed the separate appeals, my lord, in other cases. And apart from 8, I am taking to your lordship to order 8 through 6A, my lord. It says, order 8, rule 6A, my lord.
Yes.
My lord, sub-rule 4. The counterclaim shall be treated as a plaint and governed by the rules applicable to plaintiff. So that being the position, my lord, there ought to have been a separate application, appeal.
This question has not yet been settled. This is a settled position.
Settled, otherwise it is not settled, and that's why it has to be claimed, my lord, first of all. Secondly, my lord, I'm speaking at war, my lord. I filed many first appeals against the main order. Those the court directed me to file the second appeal in respect of the counterclaim. So this has to be settled, my lord.
Okay, heard Mr. O.P. Bhatti, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the appellants, impugning the judgment and decree passed by the Court of Learned, Civil Judge Senior Division Nalbari on 18/11/2025 in title appeal number 4/2024, whereby the decree passed on on the basis of the counterclaim filed by the present appellant in the title suit number 20/2017 by the Court of London, Civil Judge Junior Division number 2, Nalbari, was set aside. Where is the impugned judgment?
That your lordship will find at page 7 and the relevant page is 19, my lord. Nineteen. Now, my lord, discussion and the operative part. Your lordship will find. At page 31, my lord.
Trial court had dismissed the plaintiff's case
Suit.
and decreed
And-
your counterclaim.
Yes,
Okay.
partly it was decreed. And accordingly at page 31, madam.
Stop. After considering the materials available on record, as well as hearing learned counsel for the appellant, following substantial question of law is framed in this regular second appeal. Whether the appellate court, whether the impugned judgment and decree passed by the appellate court is perverse to the extent that it set aside the counterclaim of the present appellant without there being any challenge to the decree passed on counterclaim by the trial court by the other side. Stop. Issue notice to the
My lord, this court is equally important. Because I am the occupant tenant man. Occupancy tenant man. Khatian has been granted in my favor, my lord. The court has come to the conclusion without any pleading on that aspect.
number 2. Whether the finding of the appellate court that the present appellants are not the occupancy tenants in respect of the scheduled land is a perverse finding. Inverted comma close. Issue notice to the respondents. The appellants shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order. Returnable on 2nd of March. Before that, Lekhibo outline, this appeal is admitted. Then, after issuance of notice, let the records of the trial court as well as the first appellate court be called for. The registry to take steps for requisitioning the aforesaid records. List this matter accordingly.
In the meantime, I will be stay petitions there.
But so and so. But Mr. Opi Bhatti. This application this application under Order 41, Rule 5, read with Section 151 of the Code of Civil Procedure 1908, has been filed in connection with Regular Second Appeal number 2/2026, praying for stay of the execution of decree dated 18/11/2025 passed by the Court of Learned Civil Judge Senior Division, Nalbari, in title appeal number 4/2024. The said appeal has been admitted by this court, and after framing of formulating substantial question of law, notice has been issued to the respondent side. Stop. Let the notice be issued to opposite parties. The applicants shall take steps for issuance of notice to the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 2nd of March. Till the next returnable date, the execution of the impugned decree of the appellate court shall remain stayed.
Item 16.
May it please your lordship. Here, my lord, I am the co-sharer of a decretal land, my lord. When the execution was started, I came to know and file an application under order 2197, my lord. That application initially did not consider by the Munsif, my lord. And subsequently on appeal, my lord, misappeal, that was also dismissed. Against this, my lord, this present second appeal, my lord. I have formulated a separate substantial question of law.
No, it has to be in the memo of appeal.
In this, we have given, but subsequently I have modified the substantial question of law, my lord. In the memo of appeal also I have mentioned, my lord. My lord, impugned judgment, started from page 47, my lord. Here, my lord, what happened? I am the sister, my lord. Then the brothers contested a suit of a easement-ary right. That suit was decreed, subsequently it was put on execution. And I came to know and file an application under order 21 rule 97, my lord.
In whose land is in your possession?
I'm the co-sharer, my lord. Co-sharer. And I'm the sister. Brothers were made parties, my lord. Brothers
In respect of a plot of land.
plot of land.
How much land?
A plot of land regarding a passage, my lord. They are seeking for easementary right over that passage, my lord.
Okay.
And that suit was decreed, my lord. Subsequently, well, initially it was dismissed, my lord. On appeal, it was decreed, my lord. And that was put on execution, my lord. When it was put on execution and the year
What is to be executed? How? Easement.
easementary right over the passage, my lord.
You have blocked, somebody has blocked that right to way.
Yes, yes. This is the defendants, my lord, defendants.
Your brothers.
My brothers. And we had a co-share, my lord. Originally, it was, my lord, my father was the owner of the 1 Katha 19 lesses of land. He died, my lord, subsequently, and the brothers were impleaded in the suit. I was not impleaded. So I approached the executing court through an application under 2197, my lord. And the trial court as well as the affiliate court did not consider my application, stating as my brother were parties to the suit, so I am not liable to be in this order 2197 application to proceed with the execution, my lord. As my brothers were the parties. So the first appellate court as well as the trial court did not dismiss my contention that I am the co-sharer. So here is the main issue, my lord, in the substantial question of law, whether a decree can be executed on a co-sharer who is not the party to the suit. Now, the trial court as well as the first appellate court was held.
In whose possession the land was?
It was the defendant, my lord. That's why they are the brothers, my lord. And I'm the co-sharer, one of the co-sharers.
Whether you were in possession over the said plot of land?
No, we have position in deep. I'm the co-sharer, my lord. The question of position doesn't arise, my lord. Here, my father was the owner. So the trial court, the first executing court as well as the first appellate court held that the brothers were the party in the suit. So I am liable to be, I am not allowed to be party in the execution. So my prayer was regarding the extension of my share, not the entire decretal land. That is the 6.5 acres of land. But court held that no, the entire suit land is the decretal land and decree to be executed on the entire suit land. And moreover, my lord, the easementary right, my lord, as per my lord, the provision of Easement Act, my lord, the easementary right is not allowed in the in the act in Assam, my lord. It's not applicable in Assam. And on that, my lord, the easementary right of the plaintiff has been declared. And on that, the execution put on the decree was put on execution, my lord.
But that may, your brothers have preferred appeal.
My brothers, I am not denying that part, my lord. That is the question, my lord, whether my brother can substitute me, where I am the co-share of the decretal land. Whether I'm a necessary party or not, whether I'm a proper party or not, that has to be decided by the executing court. Let the executing court decide that I'm not the necessary party. Without me, a decree can be passed.
Where is the order of the executing court? Impugn order.
Impugn order in page 48, my lord. It is started from page 48. May I read the judgment, my lord? It started from page 49. The decision and finding at page 53, your lordship may come to page 53, my lord, as regard the decision and finding. The paragraph 7, my lord. Paragraph 7. Paragraph 7 of the impugn judgment, page 53, my lord. May I read the judgment, paragraph 7, my lord? Fundamental requirement.
Yes.
A fundamental requirement.
Foundational.
Paragraph 7.
Yes, the foundational requirement.
Foundation and the requirement for the entertaining objection under Order 21 Rule 97-101 CPC is that the third party must show independent, bona fide, and pre-existing right in the property, which is the subject of the decree. In the present case, the appellant assert that she inherited a share in the ancestral property. So this part is not denied by the defendant. I am the inheritor of the ancestral property. However, she claim is based on a general assertion. It cannot be a general assertion, my lord. That is that the defendant, the decree holder must deny that I am not the true owner or the legal heirs of the ancestor, my lord. But it cannot be an assertion that her father purchased land long ago. Moreover, her own brother were defended in the suit and carried the litigation through 3 stages: trial, first appeal, and the second appeal. As no stage did they suggest the existence of her right. So I am the third party, who is the co-sharer, in the fact that the appellant claim ignorance of litigations pending for 2006 to 19, including a high court second appeal, the revision proceeding, it inherently probable, particularly when her own brothers were parties in the suit and resident in the same ancestral house. So as my brothers were parties to the suit, so my right has been extinguished. That was the finding of the first, the executing court and the first appellate court, my lord. There is no denial that I am not the co-sharer of the property. So my first substantial question of law, whether a co-sharer who is not the party in the suit is bound by the decree passed. That is the substantial question of law I have formulated, my lord. Whether I am bound by the decree which is not, I am not the party to the suit. Let the court decide, okay, you are not the proper party or necessary party to the suit, and the execution can be put on execution on my share of land. As because my brothers were party, and it is the plaintiff who is the dominus litis who has to make parties regarding, my lord, their claim, my lord. I was not made parties. And it is not denied that I am not the sister of the present brothers, my lord. So I am the owner of the 6.5 acres of land.
Read para 8 also.
Also, lordship. It is important to note that at no stage, neither in the trial nor the first appeal nor the second appeal, the High Court did the judgment debtor claim the appellant was necessary or proper. It's regarding the judgment debtor. I am not the judgment debtor. I am not claiming the right of the judgment debtor, the entire decretal land. I am claiming the 6.5 lesser sum lot land which I am entitled for. This paragraph 8 is regarding the judgment debtor. I am not the claim the property of the judgment debtor.
Yes, please read it completely.
If indeed the appellant had any specific share or possession in the land, it is expected that the judgment debtor would have raised such plea to protect her right. The executing court rightly recorded that exempt her from mere assertion. There is no material to support her alleged ignorance. The judgment debtor never pleaded in the title suit, appeal or second appeal that she was necessary party or that she has held an independent right in the pathway. Their silence throughout long litigation is a strong circumstance against the appellant claim. The court cannot now permit the judgment debtor through their sister to re-litigant issues that have attained finality. It's regarding the judgment debtor, my lord. Who are the brothers? As because my brother did not mention my name, so I am, my lord, suffered by the decree which was executed against the judgment debtor, entire suit land. First, the entire suit land is not the owner of brothers were not the owner of the entire suit land, my lord. As because the judgment debtor did not mention my name in the trial as well as the first appeal, I am aggrieved by the right over my property. So there must be a proper trial, as my respectful submission before your lordship. There must be a proper trial. The executing court must allow to adduce my evidence. And over decretal land, my lord, the 6 lesser sum land which I have made in the order 2197 application, my lord, as a schedule. I was not allowed to adduce evidence, and directly it was on the basis of the judgment debtor, whatever they have taken stand on the trial and the appeal, my order 2197 application was dismissed, my lord.
Okay, what substantial
That is
question?
the first substantial question of law, whether a co-sharer who is not the party to the suit is bound by the decree passed.
Now, what is to be executed? What is the situation? Tell me. And how much is the plot of land?
That is total plot of land, my lord, 1 katha 90 leshas, my lord.
And how much land is covered by the way? Right, over which right of way is claimed?
They first claimed the entire scheduled land, my lord, as well as the path, my lord, as the inventory rate. That is 6 feet by 73 feet.
How the land is now used?
That is covered by the defendants, my lord, the judgment debtor, my lord, as the present petitioner,
No, they are only using it as a right to way.
right to way.
Where is their land? Their own land?
They don't have the land, my lord. Their suit was directly filed for easement right.
Easement right for ingress and egress
Yes.
to which plot of land?
That is a scheduled land of the father of the defendant, the present application, my lord, applicant. And I am the co-sharer to that.
No, easementary right to exercise which kind, what easementary right to way only?
With right to way over this.
Right to way from going to which place? From which place to which place?
That was described in the plain, my lord, which place, my lord, from the north to south, my lord. Between the, my lord, schedule of the
On the southern side, the land is situated.
Of
the
your
plaintiff-
land.
Of the plaintiff. They filed a suit for right of way, easementary right, that was blocked suddenly in the year 2004 by the defendants by erecting some walls, and they have grown some trees also. Now it has grown much, is older. And their contention before the court was that there is an alternative path is available for ingress and egress. That was rejected by the first appellate court as well as by the learned dishonorable court.
Where is your land?
My land is situated on the southern boundary of the land of the defendant.
Defendant, southern boundary.
And how much land defendant has?
1
there?
kata 16 lesser.
Only this 6 feet into 73 feet land.
No, 1 kata 16 lesser is the land. And 6 feet, 6 feet
By 73 feet.
by 73 feet is the right of way through which they used to enter the house. And it connects the PWD road, which they have been using since more than 50 years.
And now that way,
Has been blocked in the year 2004,
and since then it is blocked.
blocked.
And they are using the alternative route.
The alternative road plea was taken by the defendant in the suit.
That has been decided by the,
Yes, that was
In
been
the
decided by
second
the
appeal.
First appellate court
as well as
the
in second
first.
appeal.
There are the list of dates and the.
No, but their contention is that you have not made,
Yes, that
I'm,
is,
I'm
the-
coming, let him finish, then if he has finished, then I'll come to that.
so my only contention is that, my lord, I am the co-sharer to the scheduled property, my lord. I was not made the party. When the order 2197 application was preferred, it was outrightly rejected as because my brothers were made parties and against the decree was passed against my brothers. So the knowledge regarding the knowledge of the suit and the appeal is, my lord, against me as I'm the sister of the judgment debtor, my lord. That was the finding. But my right regarding the order 2197 application, I claim the independent right over 6.5 lesses of land, not the entire suit land. That is 1 kata 16 lesses. I'm not claiming the entire suit land.
whether land has been partitioned
And the co-sharer, they were not partition, and partition, when the suit property was not partitioned, the entire.
No, therefore I ask the question that they are claiming right of way over only a plot of land measuring 6 feet into 73 feet, which does not cover the entire land.
Yes,
And you don't know where your share is over the entire land.
no, the first contention.
Your claim is only a portion of the suit land belongs to you. How you can object to that specific plot of land,
No,
which
the
is,
suit land was entire 1 kata 16 lesses, my lord.
but the right of way is only over
The declaration was sought for 1 kata 16 lesses.
1 kata 16 lechas. Land cannot be used as a right of way. Right of way has to be over a way only, a portion of land which is used as way.
That part, my lord, regarding the whether that portion is falls under my share or not, that has to be decided. I have to allowed to adduce evidence on that part, my lord. I was not allowed. I was not allowed as because my brothers were party in. That's why I was not allowed.
Yes.
That-
Okay.
That is my respectful submission, my lord. And the first substantial question of law, my lord, whether a co-sharer who is not the party to the suit is bound by the decree passed. That is the only substantial question of law which will cover the entire dispute between the parties, my lord.
Yes.
Your lordship may take up the judgment and decree passed in the regular second appeal. To understand the, my lord, whole, my lord, the scenario.
No, you answer we are not going into, we are deciding whether to frame a substantial question of law.
There is no substantial question of law is involved here because the prime contention of the petitioner hearing is that she was not made party in the suit.
Yes.
One. Second is that, my lord, there is an alternative way for ingress and egress.
No, that has already been decided.
That
by-
has already been decided.
That,
That's what,
on
my
that, we are not going.
Now, he is saying, my lord, now his submission, what I have understood, my lord, he is saying that the path of way, the easementary right, the right of way is fall under the, well, the entire from the suit lane of 1 kata 16 lesser.
That cannot be.
But yes, this
One
cannot be.
kata, if, had it been your case, but that has to be decided by the executing court.
That has to be decided by the executing court. That is by
That
respect to
has been
submission.
decided. They came up with 47 petition also, same plea.
No, that is by the judgment debtor, not by
But
me.
judgment, the plea was, Malad, plea was not different. If I may take your lordship to the petition filed by the present appellant before the learned court under order 21 rule 97, it will make everything clear. That the main contention before the learned court was that there was a right of way. There is an alternative way for their ingress and egress. That has been decided by the, my lord, first appellate court, then in the regular second appellate, then also in order of section 47 petition that came up to this honorable court, which was dismissed. They are saying that the 47 petition was, my lord, preferred by the judgment debtor and not by her. She came to know about the entire suit and etc. in the year 2019. And since she got married in Gwalpara, she did not have any visiting terms, or she could not visit the house of the defendant for more than 15 years. After that, when she suddenly visited, when the dispute arose between the brothers and the sister, where she demanded a portion of the property, then she saw a Nazir came inside the premises to execute the property. Then she got, my lord, the news of the judgment and decree, then the RSA, etc. Then she got, my lord, furious on the brothers. Thereafter, she filed the order 21 rule 97 petition. This is the whole story projected by the appellant before the learned executing court. Now, the learned executing court, relying on the judgment passed in the year 2021, this is the judgment of Rahul S. Shah, where the Supreme Court has directed that on the mere filing of petitions under order 21 rule 97, notice should not be issued unless there is a firm contention about their right, independent right over the plot of land and over the anything.
No, but she's claiming to have inherited along with her
There
brothers.
is no such partition, and this 1 kata 16 lacha land is different, and this common right of way is being used by both the defendant and we allowed, in fact, the defendant to use that, my lord, path. And we have been using this path since 1948-50. So the court came to a conclusion, because there is a water connection came through the land, then there is a telephone line, landline connection over the, my lord, right of way, this area. And this 1 kata 16 lacha land is different. It doesn't come within the right of way. This right of way, this entire path is separated from the 1 kata 16 lachas of land. It doesn't fall within 1 kata 16 lachas of land.
That to be decided by the executing
But that
court.
has already been decided by the various.
No.
That
The
has been
executing
decided.
court did not
And
decide that.
Say for example, she has a right over the right of way. My lord, how can one claim a share on the easementary right, on the right of way?
No, right of way.
While deciding,
If the.
Okay,
motion for-
okay.
while
We are
deciding,
formulating substantial question of law without disturbing the execution, without staying the execution. We'll decide. Heard Mr. Shiladitya, learned counsel for the appellant. Also heard Mr. S. Vishwas, learned counsel for the caveator / respondents. All respondents.
yes, sir.
Respondents.
All respondents.
This appeal under section 100 of the Code of Civil Procedure. Code of Civil Procedure 1908 has been filed by the appellant Alpana De, impugning the judgment and order dated 29/11/2025, passed by learned Civil Judge Senior Division Dorong, Mangaldoi in Miss Appeal number 9/2022, whereby the appeal preferred by the present appellant against order dated 28/6/2022, passed by learned Munsif number 1, Darong, in Ms. J case number 65/19 was dismissed. The aforesaid Ms. J case, that is Ms. J case number 65/19 was registered on the basis of an application filed by the present appellant under Order 21, Rule 97, 98, 100 and 101 of the Code of Civil Procedure, wherein the appellant has had claimed to be a co-sharer in respect of the suit property, and also claimed that she was not made a party in the suit. In which title suit?
Title suit number 53/2006.
53/2006, in which was decreed in favor of the,
Initially, that was the dismissed, my lord. On appeal, it was decreed. my
which
lord.
was decreed in favor of the present respondents in the first appellate stage. And the judgment and decree of the first appellate court was upheld by this court in RSA number
My lord, the RSA number 34 of 2012.
34 of 2020.
2012, my lord.
2012.
2012. Yes.
2012. After considering the submissions made by learned counsel for both the parties, as well as considering the materials available on record, following substantial question of law is formulated in this appeal. Whether the petition, whether the appellant, being a co-sharer and not a party in title suit number. What is the title suit number?
53/2006.
53/2006, or title appeal number
18 of 2008.
18 of 2008, as well as RSA number
34 of 2012.
34 of 2012, is bound by the decree passed in the aforesaid proceedings. Stop. Issue notice to the respondents. Since Mr. S. Vishwas has already appeared for the respondent as caveator, no formal notice need to be issued to the respondents. However, learned counsel for the appellant is requested to furnish. You have received the copies of memo of appeal.
Yes, my lord.
A line to continue. Stop. Let the records of
My lord, if the records are called, my lord, then the execution case.
no,
will
only
be-
miss appeal, only 97. Execution we are not calling.
It may be clarified, my lord.
I will clarify it. Let the records of Ms. J case number 65/2019, as well as Ms. appeal number 9/2022 be called for from the concerned court. It is hereby made clear that at this stage, the proceeding of title execution case number 5/2014 are not stayed. Let this matter be listed on 2nd of March after receipt of the aforesaid case.
No, it's not stayed and parties are, my lord, are at liberty to go ahead with the execution. Otherwise, my lord, it will be automatically stayed by the learned court.
No.
Right, it- my lord, this happens sometimes, my lord. Only clarification, my lord.
What clarification?
That the parties are at liberty to go ahead with the
No,
execution.
that has to be met.
Otherwise, my lord, they will take the pleas, the same objection, it will create a conflict. Again, I have to come here, my lord. Only this.
Last line production. He is not stayed, stayed, and the executing court shall proceed with the execution of the said case.
Much obliged.
I'm like,
Order Appeal 18.
Lordship, इसमें तो मेरे पास होगा बहुत timing lordship. Senior counsel is on next.
On, okay. Item 18. Okay.
19.
May I please your lordship. Lordship, in this case, ID card has not been received in respect of respondent number 2. As per office note dated 8/1/2026, lordship. I may be allowed to take fresh step, lordship, to prepare publication. Respondent number 2, lordship.
Heard Mr. R. Sharma, learned counsel for the appellant. On perusal of the office note dated 8/1/2026, it appears that the service report of the notice issued to respondent number 2 has not yet been received back. Stop. Learned counsel for the appellant prays for allowing the appellants to take steps for issuance of notice by substituted mode of paper publication of the notice in the newspapers. The prayer is allowed. The appellant shall take steps for issuance of notice by publication of the notice in 2 newspaper widely circulated in the last known address of the respondent number 2. The date of appearance to be mentioned in the notice shall be March. 6th of March. The appellant shall take steps within 15 days from the date of this order. List accordingly.
Apply, lordship.
Item 20.
Your lordship, according to office note dated 7/1/2026, respondent number 6 has appeared. The respondent number 5 service report is still awaited.
Respondent number 5.
Has not appeared, your lordship. We have taken steps.
When have you taken steps?
Your lordship, it was taken on 24/9/2024, your lordship.
You have to take fresh steps. Heard Miss K. Sharma, learned counsel for the appellant. Also heard this is item number
20.
20. Mr. D. Nandi, appearing for respondent number
This, for the, except the performance respondent.
for all the respondents,
Yes.
except respondent number 4. Except respondent number,
The performance respondent up to 1 to 4, I am.
you are appearing for all respondents.
Yes.
Respondent number,
Performance.
respondent number 1, 2, 3, 4. Miss, what is your name? Miss S. Ahmed appears for respondent number 6. As regards respondent number 5, notice you have to take fresh steps. No. As regards respondent number 5, notice no service report has been received. The appellant is directed to take fresh steps by speed post as well as by usual mode within 7 days from the date of this order for issuance of notice on respondent number 5. Let this matter be listed on 23rd of February.
Item 21.
Earlier, I have sought for time to file objection. But since I could not file, I leave it to your lordship. Only thing I pray that my objection may be recorded.
How much, it is a condonation application?
Yes.
How much delay is there?
226 days.
226. What is your ground?
My lord, the ground is originally the present appellant is not a party in the present case.
From?
Originally, the present appellant is not a party in the present case. Her husband was the party.
Okay.
But unfortunately, her husband expired on 11/4/2018. And thereafter, she was implicated by the claimant in the tribunal.
Who are you?
I'm the wife of the owner of the vehicle.
Owner of the vehicle.
The owner already expired.
Owner has been made liable.
The owner has been made liable.
Okay. What is your,
50-50 share.
what is your objection?
I say that the explanation provided for condoning the delay is not sufficient.
Okay. Heard Mr. A.R. Talukdar.
Aye, Talukdar.
Sorry, I.A. Talukdar, learned counsel for the applicant. Also heard Mr.
A. Bhattacharya.
A. Bhattacharya, learned counsel for respondent number
1.
Respondent number 1. Any other respondent? Mr. N. N.I. Akan. N.I. Khan, appearing for respondent number 10.
Number 3 to 6.
Mr. What is your name?
M.A. Ansari on behalf of S. Salim.
M.A. Ansari.
M.H.
M.H. Ansari, appearing for respondent number
3 to 7.
3 to 7. What is your name? What is your name? Miss P. Kakoti, appears for respondent number 2. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant Mrs. Rahima Begum Chaudhary, praying for condoning the delay of 226 days in preferring the connected appeal, whereby the appellant has impugned the judgment and award dated 8/1/2024, passed in MSC case number 212/2017 by the Motor Accident Claims Tribunal, Kamrup Metro, whereby the respondent number 2 was directed who will pay 50% other
Other by the insurance fund. Bajaj.
directed to pay 50% of the compensation amount of rupees 19,51,100 along with an interest of 6.5% per annum to the claimant respondent. Learned counsel for the petitioner has submitted that the present petitioner is the wife of the original owner who had expired during the pendency of the
Proceeding. MSC
of
claim.
the proceedings of MSC case number 212/2017. Where are your grounds?
My lord, in my miscase, my lord, the medical certificate is there, my lord. Due to her medical certificate, she unable to appear before the court and contact with his engaged counsel. The order was, my lord, order was reserved on 8/12/2023 and the order
Learned
was.
counsel for the petitioner has submitted that the petitioner was unable to prefer the connected appeal within the prescribed period of limitation as she was suffering from various ailments.
There are 656. There are 3, my. 3. There are 3.
He further submits that the petitioner has stated the reasons for failing to approach this court within the prescribed period of limitation in para number 3 and 4 of the instant condonation application. He submits that the petitioner has been prevented by sufficient cause from preferring the connected appeal within the period of limitation. Hence, he prays for condoning the delay of 226 days. On the other hand, you have objections on the, only on the other hand, learned counsel for the opposite party claimant or insurance company.
Insurance company.
Opposite party number
1.
1 has objected to the condonation of delay of 212 days, 226 days on the ground that the petitioner has failed to prove the existence of sufficient cause which prevented her from approaching this court within the prescribed period of limitation. The other respondents have not raised any objection to condonation of the delay. I have considered the submissions made by learned counsel for both sides. I have also gone through you have annexed any documents?
Yes, my lord.
I have also gone through the medical documents. Where are those?
23. Last page, my.
Next, with the condonation of delay application by the applicant in support of her contentions. Considering the grounds stated in paragraph number 3 and 4 of the instant interlocutory application to be sufficient grounds which prevented the applicant, wherever I have stated applicant, petitioner, applicant, beleg nidibo. Use only one term, applicant. Prevent, last line kya asile? To be sufficient cause which prevented the applicant in approaching this court within the prescribed period of limitation, this court is inclined to condone the delay of 226 days and accordingly does the same. Stop. This interlocutory application is accordingly allowed. The registry is directed to register the connected MAC appeal and list the same for admission after 7 days on a date to be fixed by it.
I'll sub the copy to all my colleagues, learned colleagues.
Now, after registration,
Yes. I'll sub the registration.
Okay.
Item 22.
Like.
The lordship pleadings have been completed.
May I please your lordship, I have instruction to constitute their prayer for transfer.
Okay,
it
you
will
are
be the-
husband or wife?
I am husband.
Okay, heard Ms. K. Sharma, learned counsel for the petitioner. Also heard Mr.
G. Khandelia, Lord.
G.
Khandelia.
Kandelia, learned counsel for the respondent. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Srimati Nandini Sureka, praying for transfer of matrimonial case bearing TS within bracket M case number 18/2025, which is presently pending before the Court of London District Judge Soraidev, to the Court of Principal Judge Family Court Kamrup Metro at Guwahati. Kamrup Metro has the okay, jurisdiction is there. Okay. Kamrup Metro at Guwahati. Stop. Learned counsel for the respondent has submitted that he has been instructed by the respondent not to oppose the prayer, and he has no objection if the aforementioned case is transferred to the Court of Learned Principal Judge Family Court Kamrup Metro, Guwahati, as prayed for by the petitioner. Stop. Considering the submissions made by learned counsel for the respondent and the fact that the respondent is not opposing the prayer, as well as the fact that the Court of Principal Judge Family Court Kamrup Metro also have jurisdiction to entertain the aforesaid matrimonial dispute, the title suit within bracket M case number 18/2025 is hereby transferred to the Court of Learned, which is presently pending before the Court of Learned District Judge Soraidev, is hereby transferred to the Court of Principal Judge Family Court number 1 Kamrup Metro at Guwahati. The Learned District Judge Soraidev is directed to send the records of the aforesaid title suit so as to reach the Court of Principal Judge Family Court Guwahati on 2nd of March, where both of you have to appear on 2nd of.
I have a small prayer. I have it written in my para number 12 of the written objection. Lordship, my father is under diagnosis. So as and when effective hearing is not there, I may be allowed to appear through video conference. That is only my prayer. Otherwise, we will appear.
That prayer you may make before the.
That observation will help me, Lordship. Only
Okay.
that.
Since both the parties are represented by their engaged counsel before this court, both the parties are directed to appear before the Court of Learned Principal Judge Family Court number 1 Kamrup Metro Guwahati in the aforesaid case on 2nd of March.
Lordship, it can, because third will be a holy. So
No,
it will be.
You need not to appear on 2nd of March. You have to appear on, say, 16th of March.
Much
On
obliged,
16th
much
of March. The learned counsel for respondent has prayed for allowing the respondent to appear in the aforesaid proceeding through video conferencing, considering the ailment of his father. Stop. This court, since the matter has been transferred to the Court of Learned Principal Judge Family Court number 1, the said prayer shall be considered by the trial court as and when such prayer is made by the respondent. With above observation, this transfer case is disposed of.
Much obliged. Item 23.
My lord, in this case, some time may be given to me to take the instruction whether really he opposed
Your husband,
for the respondent.
husband or wife?
Husband.
Husband,
Okay, let him take instruction.
instruction, whether he really opposed. To me, I think that there is nothing to object, but
Okay.
still I
Okay,
want to take the
okay.
instruction.
Heard Miss, what is your name?
Miss Anil A. Deka.
Heard Miss A. Deka, learned counsel for the petitioner. Also heard Mr. P. Upadhyay, learned counsel for the respondent, who submits that some time may be granted to the to him to take necessary instructions from the respondent as to whether he is inclined to concede to the prayer of the petitioner regarding transfer of title suit number 18, title suit within bracket D, number 18/2025 from the court of Learned District Judge Udalguri to where?
Family Code Borpeta, my lordship.
To the family court Borpeta. The prayer is allowed. How much time?
2 weeks.
Let this matter be listed again on
My lordship, can it be on 11th or 10th?
11th February. 11th.
11.
Let this matter be listed on 11th February.
Nice.
Timing item 18.
May I please, lordship, I beg some time, lordship here. I couldn't prepare the matter. Can it be?
Not Mr.
M.K. Majumdar,
M.K. Majumdar, learned counsel for the
petitioner.
petitioner. None has appeared for the respondent. The petitioner has appeared, learned counsel for the petitioner has prayed for some time on the ground of personal difficulty. The prayer is allowed. Let this matter be listed on
4th week,
when?
4th week February.
26th of February.
Obliged.
Item 25.
Let me, your lordship. Lordship, as for office note dated 22/1/2026, neither AD card nor unserved notices as well as service report have been received. Lordship, postal journal and postal tracking have been enclosed at flag number J and T. As per postal tracking, notices were delivered on 3/11/25.
How many respondents are there?
Lordship, 2.
The IA is for?
I'm extremely sorry, lordship, I don't have the brief with me. The brief is my senior lordship.
Heard Miss, what is your name?
S. Das.
Heard Miss S. Das, learned counsel for the appellant. Who submits that as per the postal track consignment report laid before this court by the registry, it appears that the notices sent to respondent number 1 and 2 have been delivered to both the respondents. Stop. Peruse the office note as well as the postal track consignment report. On the basis of the postal track consignment report placed before this court by the registry, it appears that the notices sent to respondent number 2 and 1 and 2 have been delivered on to them on 3/11/2025. Accordingly, the notices are held to be duly served on the aforesaid respondent. It also appears that the records of the trial court as well as first appellate court have been received. Let this matter be listed for hearing on 5th of March.
His lordship.
Item 26.
May it please your lordship. Lordship, as per office note dated 22/1/26, respondent number 1 and 2 has entered appearance. No ID card in respect of respondent number 3 and notice of respondent number 4 was received by his father. We'll take fresh steps upon respondent number 3, lordship.
Lordship, I have not received the copy of appeal memo, so appellant may kindly. That may kindly be recorded, Lordship. I have not received the copy.
What?
I have not received the appeal memo, Lordship.
No, they will furnish you.
We'll be punished.
Heard Miss,
No,
second,
because
Lordship.
heard
he's
Miss,
the proxy counsel, so the matter.
heard Miss M. Sake appearing
On behalf of.
on behalf of Mr. T. Kalita, learned counsel for the appellant. Also heard Mr. A. R. Agarwal appearing for respondent number
1 and 2 claimants.
1 and 2. Stop. On perusal of the office note dated 22/1/2026, it appears that the notice issued to respondent number 4 has been received by the father of the respondent number 4. Stop. Hence, comma, the notice issued to respondent number 4 is held to be duly served. As regards respondent number 3 is concerned, no service report has been received yet. Stop. The appellant is therefore directed to take fresh steps for issuance of notice upon respondent number 3 and 4. 3 by speed post as well as by usual mode within 7 days of the date of this order, returnable on 26 February. The appellant shall furnish memo of appeal along with annexures to the learned counsel for the respondent number 1 and 2 within 2 days from the date of this order, list accordingly.
Obliged, lordship.
Item 27.
In item number 27, lordship, respondent number 1 and 2 has entered appearance. Notice of respondent number 3 was received by himself. And no ID card or answer of notice in respect of respondent number 4.
Same.
Same, Lordship, but here,
Here, respondent number
here
4,
the
we have to take
owner,
steps, lordship.
owner has been served, Lordship. The interesting, there are analogous cases, but owner has been served, Lordship.
Same. Councillor Nam Eke Likhibo. On perusal of the office note dated 22/1/2026, it appears that notice issued to respondent number 3 has been received by him. Hence, the said notice is held to be duly served on respondent number 3. As regards respondent number 4 is concerned, no service report has been received. Stop. The appellant is, therefore, directed to take fresh steps for issuance of notice upon respondent number 4 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26
Copy of
February.
appeal.
Same order, copy of memo of appeal, list accordingly.
Yes, lordship.
Item 28.
May I please, your lordship. Lordship peruses the last order, that is order dated 15/12/25.
Yes.
Lordship has directed us to take steps on respondent number 1 and also have directed the respondent number 2 to take instruction from respondent number 1, since in code below the the respondent number 2, the council is the same and they have filed a joint application. So we have taken steps and it has returned back again with the same instruction that on by office note dated 22/1/26 that the address was insufficient. No, no, this case is basically with regards to appointment of guardian ad litem. An application was filed by the.
No, but regarding steps, notice, who is appearing for the other respondent?
Last date, Lordship, BD Deka and M Das have appeared.
Today they have not appeared.
Today they have not appeared.
What is to be done? What is your submission?
Lordship, since they are appearing for respondent number 1 also in the lower.
No,
court.
but last time a query was
Yes.
posed for,
And the application which they have filed was a joint application by the respondent number 1 and 2 before the court below.
no, unless they make a
Yes,
submission
That's-
before
that's-
this.
But they are not.
We'll list it next week.
Not.
Heard
F for review.
Mr. F. Faridi, learned counsel for the petitioner. None has appeared for respondent number 2. On last occasion, a request was made to Mr. M. Das, learned counsel for respondent number 2, to take necessary instructions as to whether he may also appear for, he may accept notice for respondent number 1 or not, as it was submitted before the court, that before the trial court, both the respondents, that is respondent number 1 and 2, have made joint application on the basis of which impugn order was passed. So since no one is appearing, no one is present before this court on behalf of any of the respondents, let this matter be listed in the next week, 4th of February.
Much obliged.
Item 29.
Yeah, please, Your Lordship. Well, here in this case, earlier notice was issued. And we have challenged the order dated 29.
But what happened to the notice?
Notice service is not completed.
Not completed.
Notice is duly served. If there is, he said duly served.
1 to 5.
Duly served?
My lord, if my friend is saying, I think that is not there. Because notice we have taken.
When?
My lord, on 16/10/2020, as per official.
We'll direct the registry to place the track consignment, postal track consignment. But
May I prefer, my lord, to pass an interim order pending, my lord, suspending the further proceeding, my lord.
no interim order now, because it was,
Yes, sir.
let the notices be served first.
Well.
Heard Mr. A.R. Sikdar, learned counsel for the petitioner. On office note, on perusal of the office note dated. No, notices has returned without service,
Oh.
not found.
But the address given by us, that is the address of their original address in the suit. Their original address is Koirabari, Mouza, Govardhana. Koirabari, Mouza, Govardhana.
Notices sent to the respondent number 1 to 5 by way of speed post have returned without service with endorsement within inverted comma not found stop RTS, inverted comma clause. Whereas notices issued by usual mode, you have taken steps. No,
I have not.
the petitioner is directed to take fresh steps for issuance of notice upon the aforesaid respondents by usual mode as well as by speed post again, returnable on 20th of February, list accordingly. The prayer for interim relief would be considered only after due service of notice upon the respondent.
The address is same, they are, my lord, intentionally avoiding to receive the notice.
By usual mode, you,
Yes, my lord,
you
can.
take steps.
Item 30 and 41.
May I please, your lordship? Lordship, this is a matter, contempt matter and a civil revision matter, which arises out of an order of a family court, my lords. My lords, in the last occasion, my lords, the matter was listed before the division bench, and the division bench took a view that since this is a civil contempt matter, so therefore it should lie before the single bench. In the last order, and therefore, as if today, my lords, it has stood before your lordship.
Yes.
Millets, basically, the parties have gone through multiple rounds of litigation, Millets. Therefore, I request some leeway to argue this matter. Millets, in this case, so what has happened, Millets? The petitioner and the
No,
respondent.
no, today this is fixed in orders column.
Orders column, Millets, because what has happened that in the contempt matters, pleading has been exchanged. Pleadings are complete in that regard, Millets. But with regards to CRPIO, because on the last to last date, so what has happened at Millets, this honorable court, when it stood before the division bench, it was ordered that the CRPIO would be listed along with this contempt petition, Millets.
Yes, is it listed today?
Yes, Millets, CRPIO.
What contempt you are alleging?
Yes, Millets. So basically, Millets, we fall back upon page number 11 of our contempt petition, Millets. So I am the petitioner father, Millets, and she is the respondent mother. Millets, basically we are distant cousin. So basically we are from the same ancestry. Millets, in page number 11, Millets. So when the son was just 6 months old, Millets, she had made an allegation that we tried to kill her. And on the basis of that, she has left her matrimonial house. And thereafter, Millets, the trial has been conducted whatsoever, Millets, we have demolished her in the cross-examination. That's a different aspect of the matter, Millets. As of today, Millets, we have filed a custody petition, Millets. And thereafter, Millets, by the learned trial court below, by the order that is 79/2024, my lord, has it? 79/2024 on page number 11 of our contempt petition, Millets.
Yes.
So, Millets, it is said that petition is parties are present with their amicus curiae. Seen the petition filed by the petitioner under section 12 of the Guardianship and Wards Act, seeking interim custody or visitation right of the minor child. Heard the parties and their amicus curiae on the prayer of the petition. The petition is disposed of with the order that the opposite party, Samima Abdur Atik, will produce her child in second half of every second and fourth Sunday of the month in Gormur Police Outpost under Jorhat Police Station, District Jorhat. The petitioner Manzil Hussain will meet the child Natik Hussain in Gormur Police Outpost under Jorhat Police Station, District Jorhat, and so and so. Millets, we had
in CRP, who has filed the CRP?
I have filed a CRP, Millets.
Which order has been impugned?
Same order.
This
So,
order.
No, not. There are a serious order. If I have the CRP, Millets, my lord, have the file CRP file, Millets. So pursuant to the 7/9/2024 order, my lords, so there are two issues with this order, my lords. The one being that, my lord, it was in the police station. Since the respondent is an ACS officer there, we said that there is a intervention by the police every time we tried to visit. Thereafter, my lords, what has happened in page number 30 of our, my lords, CRP, page number 30. my lord has it, page number 30 of our CRP, my lords.
Yes.
In page number 30, my lords, we have filed a petition seeking the modification of the order dated 7/9/2024, my lords. On that petition, my lords may come, we have also written an email to the Superintendent of Police Jorhat saying that how he has been obstructing our visitation with the child. Pursuant to that, my lords, if my lord come to page number 47.
Who is obstructing?
The police officer and the mother, because both, what happens, my lords, he's an ACS officer in Jorhat. Now, my lords, if my lord.
Mother is an ACS officer.
Yes, my lords, posted at Jorhat. So this police outpost which where the
And
visitor.
what do you do?
I am a financial consultant working with the secretary. I am a private consultant, my lords.
Okay.
Okay, ma'am. So what has happened?
How old is the child?
6-year-old, my lord.
6 years old.
6-year-old minor child. And admittedly, my lords, of many allegations that the mother has made against me, one of her primary allegation is that it is admitted fact by her in her pleadings, my lords, that she does not want to produce the child because the child does not recognize me. That is her, my lords, stand. Well, now what has happened, if I may just take my lords through page number, straightly to the prayers that I have asked. My lords, in page number 36.
Whose petition is this?
This is our petition. This is the petition I filed pursuant to order dated 7/9/2024, where my lords, an interim visitation was given to us.
Yes.
My lords, page number 36.
Yes.
Lords, in this case, in the learned trial court below, we have filed a petition number 1911 of 2024. My lord, may kindly note petition number 1911 of 2024.
Yes.
Yes, my lords. So, my lords, in this thing, we say that allow this instant application modifying the order dated 7/9/2024, providing interim physical custody on the minor child to the applicant. Then second, we say that allow this instant application modifying the order dated 7/9/2024 and allow the applicant to stay overnight with his minor son on weekends. Allow this instant application modifying the order dated so-and-so of directing the opposite party or anyone else to refrain from interrupting the applicant's meeting with the son. Direct the opposite party to coordinate in providing child professional counseling, my lords, in Guwahati. Then direct to engage in video call and so-and-so, my lords. And also to meet us during vacations. My lords, thereafter what happens is this, in page number 40, my lords. So on the first date of visitation, when 7/9/2024, my lords, the first date of visitation was 22/9/2024, my lords. My lords, for your perusal, my lords, I have also brought a written submission for the dates.
No, before that,
Yes,
you just come to point.
Yes, come to point.
Which order
Yes, my lord.
you are
Yes.
alleging contempt?
Yes, my lords. So we come to page number 47, my lords. Page number 47. Page number 47, my lords. We press this petition. My lords, has page number 47?
47 is a
No,
no.
sorry, ma'am. 42, my lords. 42. 42, which is order dated, my lords, 13/2/2025 of CRP. 42, my lords.
Yes.
So, my lords, here we have said the parties are present. Petitioner has prayed for an order on his petition number 1911/2024, filed on 25/11/2024. So the learned court has made an opinion that the case is heading for final disposal. Therefore, I do not want to dispose the petition at this stage. However, the petition of the plaintiff would be considered with along issue at the time of argument. On the next order, my lords. On the next order, my lords, that is of 3/4/2025. My lords, during her cross-examination, she has actually made a lot of allegations against me and my mother and my father, my lords. So therefore, we have filed an additional evidence. However, my lords, the learned court below, if you see the last para, parties are directed to appear before the learned counselor for counseling today. So on that day, my lords, the learned trial court below had sent us for, my lords, for mediation. And thereafter, my lords, on 6/9/2025, my lord may kindly note that 6/9/2025 is the date when, my lords, 3 dates of mediation was over. And in between that, my lords, from 27 July 2025,
Yes.
my lord may also note, which I'll bring to my lord's attention in contempt petition, that from 27 July 2025, my lords, the respondent has stopped bringing the child to the visitation site and complying with the order dated 7/9/2024, my lords. So this CRPIO, my lords, is basis of this order that with regards to our application for modification of our visitation order, my lords, just because, my lords, there's been no effective order passed, therefore we are not being able to effectively meet our child. That is the issue in our CRPIO. With regards to the contempt petition, my lords, the subsisting visitation order, which has not been modified, my lords, by the learned trial court below, my lord, despite that, she has not brought a visitation order, saying that on the allegation that, my lords, on 13 July 2025, my lords, we have brought cousins to obstruct her at the police station, my lords. My lords, that I will counter in my contempt petition. But however, my lords, this is the gist of the reason why we have challenged the orders of the family court in this CRP. My lords, before I go into the merit of the matter, my lords, I want to just bring your lord's attention, my lord's attention, to only 2-3 pages, my lords. My lords, I have also brought a written submission, my lords,
In which matter?
in CRPIO, my lords. But only 2 submissions, my lords. These are few dates, my lords, because the parties have gone through multiple litigation. Sorry to service copy.
No, are we taking up CRPIO?
CRPIO, my lord.
Then we'll fix it for admission hearing.
No, my lords. Then contempt matter also. Then I'll like to argue the contempt matter, my lords. CRPIO, because contempt what has happened, my lords. is this.
Can we dispose of CRPIO today, Mr. Rashid?
My lord, CRPIO, I am to file reply because, my lord, your main case is the contempt case. So CRPIO, my lord, it is tagged with this. Why, my lord? Here is a reason. My lord, my learned friend, husband of my client, my lord, he filed a guardianship case, claiming guardianship of the boy.
No, CRPIO does not have any relationship with the contempt case.
No.
Contempt is alleged of this,
So contempt case is
of
another
the
aspect.
family court's order.
Yes, ma'am.
So
It's of
how?
the family court's order, but it does not have any link with it.
Link.
But thing is this, my lord, why it is called? Because, my lord, as my learned friend pointed out, that they have filed a petition. By that petition, they prayed before the trial court that the visiting right may be extended. It is given for 2 days in a month. 2 days in a month, it should be weekly, that 4 times. That was their prayer. That was not allowed. That was not allowed. What happened, my lord? Now their petition is pending. Immediately they came before your lordship, filed this CRPIO, challenging that petition. When this
No,
order is not
challenging
passed.
which order? In CRPIO, which order?
That their prayer is this, my lord, in the CRPIO, that our petition is not disposed of. Our petition is not disposed of. that
Petition for
visiting right is
modification
not
of order dated 7/9/20.
2024, my lords.
Because it is pending before the councillor.
No, my lords.
Matter is,
If I may submit, my lords. So 7/9/2024, my lords, the visitation order was given. Then thereafter, my lords,
you filed an application for modification.
modification of that order.
1911.
2024.
Yes.
That, my lords, was taken up on 13/2/2025.
But that is not yet disposed of.
That is not yet disposed of. And in between that, my lords, they have actually they have done contempt because that 7/9/2024. So if I may submit, my lords, one is a contempt case where we are saying that now 7/9/2024 order they are not complying with. There's a separate limb of the matter. The other limb of the matter is that even if, my lord, 7/9/2024 order is allowed, the way the circumstances this C creates for us, my lords, for which we had file a 19224 petition, my lords, that has to be modified because we have to go to a police station, my lords, where, my lords, timing is not given. We also ask for, my lords, video call and all these aspects. We also ask for, my lords, access to the school. My lords, therefore, if I may argue the CRP, my lords, today.
No, CRP, he will be filing.
Yes, my lords, CRP he will be filing. Then I'll take up the contempt matter, my lords, in very short.
Contempt can be disposed of today on.
Yes, my lords.
Mr. Rashid.
Pleadings have been exchanged, my lords.
My lord, that can be. Here, my lord. In CRPIO, my lord. Petition is pending. Decision is not taken by the trial court.
But there is a subsisting order,
My lord,
7-9.
7-9 order is there. For that, my lord, they want that it should be 4 times monthly. That petition is pending before the trial court. During that,
No, their contention in the contempt petition is that the 7-9-24 order.
no, I'm not on contempt, my lord. Contempt, I will say,
On,
on
we,
this
we are not taking up CRP now.
my lord.
CRP will be taken up after you file your written objection.
Yes, ma'am. In that case, my lord, will come to the contempt.
In CRP, I will likho. Heard Mr. What is your name?
Emberman, my lords.
M. Burman, learned counsel for the petitioner. Also heard Mr. M. A. Rashid, learned counsel for respondent, who submits that he may be allowed some time to file written objection against the petition filed by the petitioner in this CRPIU. The prayer is allowed. Let this matter be listed when on 20th of February.
4 weeks time may be granted. 4 weeks.
It will be.
On 2nd of March.
Yes,
2nd of March. Now, what will happen to this contempt?
Contempt, ma'am.
Contempt, my lords. Yes.
So, my lord, may I submit, ma'am? Your lordship,
No, before that, your crux of your submission is that 7-11
7-9-2024, my lords.
order has not been complied with.
Yes, my lords. There are, so basically, my lords, what has happened, there is multiple litigation between the parties, my lords, as I already said. So, look, my lords, see, her always the allegations she has filed, always, my lords, police complaint for whatever we do. Now, my lords, the reason, my lords, because what we already submitted, my lords.
Contempt of court acts. Contempt of court acts.
My lords,
Yes.
yes. So in this case, my lords, in the list of dates I have said, my lords, 7-9-2024, what happens is, my lords, that our first visitation order was given. My lords, I'd just like to give a little preface. My lords, this is not material to contempt matter, my lords. Actually, what has happened, my lord, that I want to argue that she has always obstructed our visitation. She also filed a transfer petition before this honorable court. When the transfer petition was dismissed by this honorable court, then she files and goes contests the case therein. But that is not material. But I just want to reflect her conduct. My lords, on the very first day of our my lords visitation, my lords, there was an obstruction created by her. My lords, in various dates, such as my lords, in 25/5/2005, many dates she will not come to the date of visitation. And whenever she comes, my lords, I want to read the order dated 7/9/2024 again, my lords. My lords, that is in page number 11. My lord has it. Page number 11. Only the last paragraph.
Just a minute.
My lord has it. If I may read.
This contempt petition is under which provision?
My lord, this contempt matter is under the Then 2 and 5 Constitution read with section 10, 11, 12 of Contempt of Court Act, as well as Rule 9 of Contempt.
How 11-12 comes?
Yes, my lord. My lord, 10 will come.
10 will come.
10 will come, my lord.
Whether proviso would be applicable? Read proviso.
No, my lord, it will not.
Why?
Because, my lords, that was a categorical finding of the court by the previous court, since this is not a criminal contempt. Because the proviso will only apply, my lords, when it is a nature which will be which will be offense under IPC. Because this is willful disobedience of, my lords, a court under, my lords, family court.
Why it will not be an offense under IPC?
Plus, that was the categorical finding of the Mellots, the previous, this thing, previous order Mellots. If may refer to order dated Mellots. Order dated Mellots 9/1/2026.
No, yes, read. This contempt petition is not contempt of order of this court,
Yes, Mellots.
but of a subordinate court.
Yes, Mellots.
Therefore, proviso to section 10 would be applicable. You have to overcome that proviso first.
Yes, Mellots, but however, Mellots, however, Mellots, this is a proviso, Mellots,
Putul, IPC.
for it has to be an offense punishable under IPC, Mellots. But as of what I find, Mellots, the contempt that has been done by her by not visiting the child to the complying with the order dated 7/9/2024, Mellots. In my humble submission, I don't find it, Mellots, that it is any offense made under IPC, Mellots. Because, Mellots, the definition of the Contempt of Court Act, where criminal contempt has been defined, Mellots.
Yes, what has been defined?
It has been defined that criminal contempt means that, Mellots, publication, whether by words spoken or written or by signs or by visible representation or otherwise of any matter of doing any act whatsoever.
No, this is not a criminal contempt.
Yes, Mellots.
Nobody is saying that it is.
Yes, exactly, Mellots. So, to fall back upon the proviso, Mellots, she has to do a contempt which is, Mellots, allegedly criminal in nature.
No.
Or has to be any offense
Yes.
which is listed in IPC.
Yes.
Yes, Mellots.
So that you have to satisfy.
Yes, Mellots.
That disobeying the order of a court, whether it amounts to any offense under IPC or not.
Mellots, no, Mellots. Because if it does not fall back within the ambit of IPC, Mellots,
Yes.
then Mellots proviso would not apply.
Yes, correct. Okay, make your submission.
Yes, Mellots. So, Mellots,
I still have a query
yes, Mellots.
on whether proviso is applicable to.
Mellots, because if we, Mellots, allege that, Mellots, that there has been some disobedience which is criminal in nature, Mellots, then we have to specifically plead on a petition that this is a offense which is, Mellots, a offense which comes under the purview of IPC, Mellots. If that is missing, Mellots, proviso would not apply, and then we fall back upon section 10. because, my lords, in civil contempt, as we see, my lords, it is willful disobedience of an order. For example, my lords, if I may submit,
Yes.
assuming for a moment, my lords, that let's say, my lords, for example, let's say the trial court below in a civil case, my lords, asks for an execution matter to happen. Let's say the court executed the court appointed LC goes for a, my lords.
No, no. The query is whether any disobedience of court's order,
Yes, my lords.
whether disobedience of court's order amounts to an offense under any of the provisions of IPC.
My lords, in my
You have to
analysis,
find out. First, you have to find out.
I have not found any, my lords, in
Yeah.
IPC. I have actually looked through, my lords. I have not found any, my lords.
Okay. Because I have encountered one provision, I am unable to recollect it.
Yes, my lords. Let's say, my lords, if a trial court below, from my humble understanding, because from my limited experience, so let's say, for example, a learned court below appoints a local commissioner, who is the hand of the court. And while appointing the local commissioner, assuming for a moment, the person below actually obstructs the local commissioner,
Yes,
then it will fall back upon the proviso, because that will be criminal contempt, my lords.
No, that will not be criminal.
Let's say it is aided by a police officer, because it has
That-
happened, my
that
lords, in
will be-
commercial cases that have appeared, my lords. The local commissioner in when the court appoints a local commissioner, my lords, and goes for a seize and seizure, then thereafter a police is also the police officer's assistance is also taken. In that matter, what happens is this, my lord, that if there is an obstruction, let's say, to the discharge of the public duty, my lords, by a police officer, by the order of the court, by a subordinate court, then proviso would apply, my lords.
Yes, in that case. Okay, make your submissions.
Yes, my
I
lords.
will-
So, my lords, we will allege that this is a civil contempt. So, my lords, in this matter, what has happened that, my lords, time and again, my lords, she has not, my lords, so if I read, my lords, page number 11 again. Page number 11, my lords. The order date, well, in page number 11, the order dated 7/9/2024. If I may read it again, my lords.
Yes,
My lord has it?
yes.
Yes. So, my lord, the last paragraph. Petition is disposed of the order that the opposite party, Samima Abdur Atik, will produce her child in the second half of the every second and fourth Sunday of the month in Gormur Police Outpost under Jorhat Police Station, District Jorhat. The petitioner, Manzil Hussain, will meet the child, Natik Hussain, in Gormur Police Station under Jorhat Police Station, District Jorhat. Now, my lords, there were two problems with the order. The two problems with the order was that, my lords, first of all,
Now, we are not concerned
yes,
with
yes,
the problem.
exactly, my lords. Thereafter,
The problem with the order will be
Yes.
taken care in the CRP.
IO, my lords.
CRPIO.
Yes, yes.
Now, your case is that this order was not complied with.
Yes, my lords. So what happened on 13 July 2025, my lords? So as I already stated, my lords, we are distant cousins. So, my lords, what has happened that there were some cousins on the summer vacation, my lords. There are some cousins who arrived at the police outpost without, my lord, our knowledge. Then, my lord, she had made an allegation that we have actually obstructed her visitation and also obstructed, my lords, obstructed her this thing in the police station. My lords, therefore, in para number 13, my lords, page number 13, my lords.
Page number
13,
13.
13.
Yes.
In page number 13, my lords, this is a, my lords, a message given, WhatsApp message, my lords, which is, my lords, sent to the husband by my learned senior colleague, my lords, himself. So, may I read it, my lords?
Yes. What do you want to emphasize?
So, my lords, they say that the child was traumatized and whatsoever, my lords, these are all fake allegations, my lords. Then, in the last line, my lords, they say, well, in the last line, I hereby inform you, that the child will not be present for visitation until his mental condition improve and he is willing to do so. Sender, my lords, my learned senior colleague himself, my lords. So, my lords, we have made these allegations. In their affidavit in opposition, my lords, I'll straightly come to their affidavit in opposition, my lords. In their affidavit in opposition, my lords, so they have made various allegations. So the main allegation remains that the child does not want to meet me, and that we have created obstruction whatsoever. Her perennial allegations, my lords, he has put. Then thereafter, my lords, in our contempt petition, my lords, we have specifically pleaded that those cousins came with birthday balloons and cakes. Now, my lords, my learned senior colleague, what had submitted is this, that on 23rd July 2025, my lords, may kindly note the date 23rd July 2025.
No, when did they stop?
From 27 July 2025.
When you went to the police station, when you could not find,
27 July 2025. my
you
lords.
went to the government police
Yes,
station.
yes, my lords.
Okay.
So, my lords, what has happened is this. My learned senior colleague had informed me by a message. Then what has happened in 23rd July 2025, they have submitted that before this court, before this honorable court, while in the contempt proceeding, that they had filed for a stay of this 7/9/2024 order, my lords. That is there in the, my lord, affidavit in opposition. In additional affidavit opposition, my lords. So in 23rd July 2025, my lords, they have filed for an stay, my lords. My lords, will, if you peruse the records of this instant contempt petition, my lords, I have categorically stated that neither I have received this application as a notice by the family court or, my lords, during the proceedings which happened after the contempt, because after the contempt also there were a few dates in the family court. There also they have never pressed that petition or neither served to us. Because when I specifically pleaded that fact, then they give us as an additional affidavit in opposition, my lords. And in this, my lords, which we stated in our contempt petition, my lords may kindly see page number 113 of the additional affidavit in opposition.
Yes.
My lords, these are the people holding balloons, my lords. The reason I'm saying this is because, my lords, there are a few more dates that I want to point it before lordship, before there are 2-3 dates, and thereafter I'm done with my submission, my lords. Now, my lords, just because he's an ACS officer, so what he has done is, my lords, just because he could not procure a stay from, my lords, the learned trial court, he went to the Child Welfare Committee. She went to the Child Welfare Committee. My lords, in their contempt petition, my lords, we have given the annexures where we have shown that on 10th of August 2025, my lords, when I went to the police station, so 27 July she stopped coming, my lords. On 10th of August 2025, my lords, when I went to the police station, now she does not come with her child. The Child Welfare Committee comes and say that we have ordered an investigation. Now, my lords, this is something, it's an established law, my lords. When the proceeding is going under the family court, Child Welfare Committee cannot intervene. And therefore, what has happened, my lords, we file a writ petition against the order of the family, against the CWC, and that was stayed by this honorable court. So she was also employing extrajudicial authorities to obstruct me from visiting my child, my lords. My lords, in my contempt petition, my lords, I have shown in page number, my lords, 17. Page number 17 of my contempt petition, my lords.
Yes.
Page number 17, my lords, they come with a, my lords, a social investigation report of the child. My lords, it's an settled law that, my lords, when a matter is adjudicating trial before the, my lord, family court, Dear Lord, my lords, engaging in extrajudicial authority. And therefore, it was rightly stated by this honorable court, my lords, which is pending adjudication. And thereafter, my lords, they have also sent a report to the family court. Now, my lord, as of matter stands today is this, my lords. Whatever the allegations may be, my lords. Today, my lords, they say that we have obstructed our visitation in the family court, in the police station, my lords. And what the dramatic event.
Have you brought this to the notice of the family court that they are not producing?
Yes, my lords. We have actually on the 6/9/2025, the reason why I filed this CRPIO, my lords, we said that, my lord, look, that they have not been producing the child. And then what the order 6/9/2025, they said that since both the cases are pending, so we will fix the 2710 for necessary order. And we have also requested them also that we don't want to go to the court. If this can be held by mediation, please do it. They say that no, if you want to do, go for contempt. And therefore, if my lord will see, after 6/9/2025, the first contempt order we have filed. My lords, we have the first order was after 6/9/2025. My lord will look.
What first order? I'm not.
The first order in this contempt petition
May
was
I-
after
may I point out one
6/9/2025.
thing, my lord, what your lordship pointed out to my learned friend, that whether they approach the trial court, that their order is violated, they did not.
Power of contempt does not lie with subordinate court, my lords.
My lord, no question of contempt, what your lordship pointed out, whether they inform the trial court that trial court's order is violated that by an application, that is not done.
My lords, application, my lords, the redundant application cannot be filed because my lords, the
Redundant
power of
application.
contempt.
Wait, we'll continue at 2.
Yes, my lord. I'm so obliged, my lords.
Before my learned friend starts, my lord, I want to point out one thing before your lordship. I filed an additional affidavit in the case, my lord.
In this contempt case.
Additional affidavit, contempt, my lord, in the contempt case.
Hmm.
So, my lord, in the additional affidavit, I have stated that on 23/7/2000, I filed a petition in the connected guardianship case, my lord. So, my lord, if my learned friend admit that, that is on record, then no problem, my lord. But if my learned friend deny that, I have not filed that application, then, my lord, that record of guardianship case, my lord, Ms. J case number 153 of 22 may be called for. Because, my lord, my entire case depend on this application. If it is admitted by my learned friend, no problem. If it is denied that he did not get the copy and the petition is not numbered,
My lord,
that
the submission is entirely
only
different.
escape is this, my lord. Only the thing is this, my lord, whether that is on record or not. If that is to be ascertained, my lord, then record of Ms. G case number 153 of 2022 is to be called for, my lord.
What order was passed on this?
No, my
Nothing.
lord, that,
No order, my lords. Nothing.
my
Lords,
lord,
I admit to the-
my humble submission before your lordship, I will request my learned
Yes,
friend
yes, yes.
that when I am submitting something, he
Yes.
should not interfere with. My lord, I filed
Okay,
this
then let
petition
him complete his submission.
23/7/2022.
Okay.
Why I am pointing out, my lord, if it is said that it is not filed, in that case will be separate one. And if my learned friend admit that it is filed, then no problem. That is my humble submission. Now he may
Okay,
come.
let him address it in his submission.
Lords, I'm so sorry for the last hearing that I'll be very brief in this matter. I'll list at point of dates. I actually in this break, actually, my lords, I took out a list of dates which regards to only contempt proceeding. My lord. And I'll move chronologically in this regard, my lords. So, my lords, on the first page,
Yes.
7/9/2024, my lords, visitation order was passed. That is, my lords, on page number 11, my lords.
Yes.
on my lord, visitation order was passed on 7/9/2024. My lord, visitation order said that it will be on 2nd and 4th Sundays, my lord.
Total contempt of principle. Yes.
Yes, my lords. Now, thereafter, what happens, my lords? When, my lords, the 7/9/2024 order was passed, according to that, the first date of visitation was on 22/9/2024, my lords. So we went to the Gormur police outpost, my lords. That was the first time I met my son when he was, the second time when I met my son, my son is 6 months old. And thereafter, my lords, there were some, my lords, there were some discrepancies done by the police and other things. There's an allegations. Now in 25/11/2024, my lords. So basically, we filed a petition number 1911 of 2024. It is wrongly written as 25. It is 1911 of 2024. My lord may kindly note 1911 of 2024, my lords. Thereafter, what may happen, my lords? 13/2/2025, my lords. The family court declined to adjudicate on our petition 1911/2025. My lords, 1911/2025, my lord may 24. My lord may kindly note 24, my lord. This should be 24. My lord may kindly note, because that is also the gist of the defense of the respondent. 1911 of 2024, because some misleading submission has been made by my learned senior colleague, my lords. 1911/2024, my lords. Now, my lords, I'll stay on 2025/2025, my lords. She did not come for visitation. That is on May 2025. However, my lords, we thinking that this to be an isolated incident, my lords, we did not file a contempt proceeding against her. Then, on my lords, on 16 June 2025, my lords, what has happened that it was the birthday of my son, 6-year-old son. And June 2025, a very important ceremony for Mohammedan is this, the Khatna ceremony that was done on the minor child, my lord. That was not informed to us. What is our information? The information was gathered because we are distant cousin, my lords. Some cousins are good to them, some cousins are good to us. So there are also some mutual cousins which are good to both of us. Then, my lords, on 13 July 2025, some of the cousins came with cake and balloons at the police store, to my surprise. Then, my lords, it is the allegation of the petitioner that we have obstructed him in the police station, and due to which, my lords, he had to go to whatsoever, my lords, then all this contempt proceedings started. Then on 26 July 2025, my lords, a message was sent to me by my learned senior colleague to my client, which, my lords, I will portray it. Then on 10 August 2025, my lords, CWC order was passed. Now, my lords, I'll kindly come to, my lords, my contempt petition, my lords. My lord, contempt petition, I'll briefly go through all the pages, my lords. Just a brief oversight, my lords. My lords, has the contempt petition, my lords?
Yes.
My lords, page number 11, as I've already submitted, is the visitation right order. Then thereafter, my lords, we have page number 12, my lords, we have written to the police that they have not come. Page number 13, my lords, where my learned senior colleague says that, my lords, because the mental health of the child will, until the mental health of the child is not improved, my lords, they will not come, because this is of the incident of 13 July 2025. They say that on 13 July 2025, we created such an incident, my lord, that it has traumatized the child. That is the allegation of, my lords, the respondent. 13 July 25, my lords, that date may be noted. Then, my lords, thereafter, what happens? On 10th of August 2025, my lords, she did not come. She had asked CWC to intervene. That, my lords, is state before this honorable court, that is pending adjudication. Now, my lords, I will come to their affidavit in opposition. Now, I'll straightly come to page number 21, that is para number 2. To their affidavit in opposition, my lords.
Yes.
My lords, they say the deponents.
No, they have not complied with the family court's order.
Yes.
This fact you have not informed to the family court.
No, we have informed, my lords, but no, my
When?
lords, because contempt, what happens, my lords, that they have not complied with the family court's order, that whether the compliance or non-compliance, either, my lords, it will depend upon the contempt. If she has not, if she has, my lords, not complied with the judicial order, then we fall back upon section 10, my lords.
No, that is not my query.
Yes, my lords.
My query is whether have you informed the family courts
Yes, my
on
lords.
subsequent day?
Yes, my lords, not through a petition, but my lords, we have already submitted that. Please take our petition again. That on 6/9/2025, my lords. 6/9/2025, my lords, may see the order that you have given in our affidavit in reply, my lords. This case, my lords, the first order date is 8/9/2025. In our affidavit in reply, my lords, my lord may complete in
No.
affidavit in reply, my lords. My lord may come.
You give me clear answer to my query,
We have informed orally, my lords. Yes.
not by filing any.
No, my lords.
Inform orally when?
On 6/9/2025, my lords. That is in our 69, page number 69 of our affidavit in reply, my lords. But however, only this order was passed.
Which order?
Plus page number 69 of our affidavit in reply.
There is no reflection.
There is no reflection. That exactly for that reason, my lord, we have CRPIO. We have filed. But even if assuming for a moment that we have not informed, my lords, even then also, my lords, this is in contempt under section 10 because he has not complied with.
That is not my query.
I understand, my lords. I understand, my lords.
Okay.
Because anyways, my lords,
Your submission is, even if you have not informed the trial court,
yes, my lords.
the jurisdiction of this court under section 10 is not affected. It
Yes,
has,
yes, my lords.
that is your submission.
Yes, my lords. Because the power of contempt does not lie before in the court below, only with the high court, my lords. Power of contempt is not, my lords, with the lower court below. Even if let's say there is no non-compliance, even if let's say we file a petition, assuming for a moment, my lords, we file a petition before the family court, saying that, my lords, that the respondent is not complying, then the family court cannot pass any effective order, in my humble submission, because ultimately the trial court has to direct us to the high court, saying that if, my lords, there is non-compliance of the order, then we have to fall back upon section 10.
Okay. Okay.
Yes, my lords.
How would you satisfy this court that the contempt which you are alleging
Yes, my lords.
is of such nature that it substantially interferes with the due course of justice?
Section 2B.
Section 13A.
Section 2B, my lords, of the Contempt of Court Act.
Yes.
Civil contempt. My lord, has it?
Yes.
So the definition of civil contempt is given, my lords. So civil contempt, my lord, has it? May I read it, my lord?
Yes.
Civil contempt means willful disobedience to any judgment, decree, direction, order, writ, or other processes of a court, or willful breach of an undertaking given to the court. Even, my lords, 2B, even if an undertaking, orally an undertaking is given to the court, my lords, even that is also subject to section 2B of the Contempt of Court Act.
What is the consequence of contempt?
Section 12, my lords. Punishment for contempt of court.
Then whether you have to overcome 13A, 13 clause A.
Yes, my lords, 13A only, my lords, only if they say that, my lords, so if I read, my lords, 13A.
Yes.
So
That is my query.
yes, notwithstanding anything contained in the law for time being in force, no court shall impose a sentence under this act for a contempt of court unless it is satisfied that the contempt is of such a nature that is substantially interferes or tends substantially to interfere with the due course of justice. So if, my lords, a judicial order is passed and that judicial order is not complied with, that is also, my lords, that is also interfere with the obstruction of justice, my lords.
Okay.
Because if, my lords, if any order is passed and that is not followed, my lords, then that is obstruction of justice. Assuming, my lords, for the moment, if the child would have been with me tomorrow, the family could have ordered that I would have to take the child to Gormur police outpost, my lords, and I would have not taken to the Gormur police outpost. Then the respondent would have come again and said that this is contempt because I would also have not followed the judicial order, my lords. That's my submission with regards to the legal aspect of it.
Okay, anything else?
Anything else? Yes, my lords. So now what is the defense? Because, my lords, it is very, very important. They have made some misleading submission. My lords, in page number 21.
Yes.
Page number 21, my lords, they say the deponent states that in compliance of connected order dated 7/9/2024 passed by the learned female judge, passed in mixed case number so and so, the deponent has been producing a child at police outpost mentioned in the order. But during the connected visitation, the child was always scared to meet his father on every occasion, and being faced by the situation, filed petition number 1911 of 2024. My lords, this is a misleading submission made on oath, my lords. Now, my lords, may kindly come to our affidavit in reply, my lords. Order dated 13/2/2025, my lords. 1911 of 2024 is a petition filed by us, but not by them. May kindly see page number 21 of their affidavit in opposition and 67 of our, my lords, affidavit in reply. Page number 67, my lords, of our affidavit in reply.
Yes.
So 1911/2024 is actually a petition filed by us, not by them, my lords.
Yes.
That being the first thing. Then, my lords, I come to straightly to page number 23. So this is, my lords, it has always been our attempt. So as he has reduced, my lords, all our visitation merely to 1 or 2 minutes. Because the police, it is at the police station. And, my lords, the police always intervenes because since he is an ACS officer posted there, whenever she go for raids or everything, she is the superior authority to the officer in charge there. And we have, my lords, therefore we have filed this CRPIO because we have said that this police outpost is difficult. Because her allegation with us that we are always trying to either kill her or kidnap her. This is a serious allegation from 2020. Now, my lords, page number 23 says, my lords, from the second paragraph, page number 23 of our affidavit in opposition.
Yes.
Let's, I may read. The deponent did not violate. My lord, has it?
Yes.
Well, so she says the deponent did not violate the visitation order of this honorable court. However, she could not produce the child for visitation as the child is not ready to meet his father. The deponent is not in a position to produce the child forcefully against his will. If the deponent applies coercive action against the child to produce him before the father for visitation, in that case, the child may suffer serious mental and physical condition. So, my lords, they have now fabricated a story that the child is going through, my lords, a mental trauma. My lords, because in the CRPIO, that's a different limb of argument where she has always obstructed her visitation to filing frivolous application. That's a different thing, my lords. But here, my lords, she says, now, my lords, if you see to page 22 also, she says that, my lords, in para number 3, I'll just turn back, my lords, to just para number 3, where it starts. As regards the statement made under para 3, the deponent stated that each and every date of visitation before 27 July 2025, the deponent produced the child for visit, but on every occasion, the child was not willing to meet his father. But for which the deponent cannot be blamed, narrating the entire situation of visit and narrating the behavior of child and a behavior of contempt petitioner, for the deponent filed petition number 1911 of 2024 again, my lords, whereby the deponent prayed for calling of record from the in charge of Gormur police outpost. Now, my lords, in para number straightly coming to, my lords, to her additional affidavit in opposition, my lords. So, my lords, may kindly note one date that, my lords, in this contempt petition, my lords, in order dated 12/11/2025 of this instant contempt petition, my lords, in before this honorable court. 12/11/2025 order.
Yes.
My lords, in that petition, in the last line, my lord. So what has happened, my lords? From 27 July 2025, my lords, he has stopped producing the child. Then, my lords, they say that 23rd July, they have filed an application, which my learned senior colleague has just mentioned, for vacation of the stay order. Now, my lords, this 23rd July 2027, my lords, my contention is this, that, my lords, even if, let's say, assuming for a moment it has been filed, has a notice been issued? The answer is no. Assuming for a moment, accepting my senior colleague's contention, that, my lords, the 23rd July petition is filed. Has a notice been issued? No. Whether on the next date, that is on 6/9/2025, before this contempt petition was ordered for the first time here, had they even pressed for this application? This contempt petition came up before this court on 8/9/2025. On 6/9/2025, my lords, we did not press the contempt application till then because there was a date before the family court. Had they pressed for this application of 23rd July 2025, the answer is no. And on that day, when he pointed out before the court, on 29/11/2025, what he does is that he files this as an additional affidavit in opposition, my lords. The 23 July petition, my lords, which he says that he has filed before the family court for vacation of the stay order, he says that, my lords, now we have filed it as an additional affidavit in opposition. My lords, from additional affidavit in opposition, my lords will see the dates. And I'll refer to only 4-5 pages, 2-3 pages of additional affidavit in opposition, my lords.
What was the contention in 23/7/2025 petition?
But that is, he has filed as an additional affidavit. We did not know until he gave us this service, my lords. It may be in the record, my lords. We are not sure. But he filed it as an additional affidavit in opposition, my lords. He filed it on, my lords, 29 November 2025. That starts from page number 80, 79 and 80, my lords. He has given the petition, my lords, as annexed as additional affidavit in opposition. So, my lords, he narrates the incident that how we went there and obstructed there, my lords. From page number 86, my lords, he narrates the incident, my lords. The respondent narrates the incident. My lord has page number 86.
Yes.
Yes. So sees that the last visiting date was on 13 July 2025 and the child was brought to State Godmore Police Outpost at 1 p.m. The present petitioner carried the child in her car and was sitting with the child along with her caretaker in her car waiting for presence of opposite party. After a few minutes, the opposite party in his car bearing registration number so-and-so along with 5 other person landed outside the police outpost. Another car bearing registration number so-and-so came behind the car of opposite party. From that car, 6 persons landed. Among the said person, there were another 3 ladies. Now, there were 20 to 30 years of age group and ladies were also 20 to 25. Then she was also named my sister. Then she says that the petitioner was afraid by arrival of aforesaid person along with opposite party and the child of petitioner was also afraid due to the presence and aforesaid person in group. Coming of the opposite party to the outpost accompanied with aforesaid person was uncalled for in a total violation of said order dated so-and-so. Now, in next para, she says, afraid by notice of presence of that group, the petitioner in compliance of APD in outpost with child in hesitating manner. That's page number 87.
Yes.
And from fear psychosis in presence of a police constable available, allowed the opposite party to meet the child. The child was scared to meet his father and caught hold of the mother and he dragged her towards car and started to cry and express his strong unwillingness to meet his father. Faced by this situation, petitioner started to return with her child towards her car, but the opposite party obstructed the petitioner and the child by standing at the door point of the outpost. However, the child escaped by the side of the father. After the child escaped, the opposite party changed his position, and thereafter petitioner came out from the police outpost. Thereafter, the petitioner and the child came to the main gate of the police outpost and noticed that 3-4 persons created, obstructed and the entry of the main gate. And they were talking to each other, bringing the car and put the petitioner's child in the car. So she is alleging that we are trying to kidnap the child. Facing that, the situation, the petitioner apprehended that they may forcefully kidnap the child from the custody of the child and started to cry. Somehow the petitioner gathered courage, managed to calm her car, holding the hand of the child. In this situation, the child was traumatized and started trembling to burst into tears. The petitioner, after sitting in the car, took photographs of the aforesaid person, and the caretaker sitting in the car made videos of the person. And the petitioner hurriedly went to her official quarter. Because in my humble submission, if my lords allegedly, assuming for a moment that this incident have occurred, she is an ACS officer. If such group of people have come to my lords kidnap the son, she is an ACS officer, she knows the rule of law. My lords, she should have stayed in the police station. Now she says that she has went out from the police station. Well, I didn't, no stress of imagination. We can imagine that an ACS officer, when an opposite party has come to kidnap a child, she runs away from police station. Then, my lord, they say that
Okay, you conclude within 5 minutes.
my lords,
Within 5 minutes, you conclude your submission.
conclude submission, my lords. Yes. Last thing, my lords, in our affidavit in reply, before this was filed, my lords, page number 103. In our affidavit in reply, my lords, I just want to, which I filed before that, only, my lords, 3 pages. 3 pages, my lords, may just come to our affidavit in reply. I will just refer to my lords affidavit in reply, my lords, which is paragraph 11, my lords, page number 49. Page number 49, affidavit in reply.
Yes,
My lord, has it?
yes.
It is said, well, we have replied before that only. Before that, filed this affidavit in opposition, additional affidavit in opposition.
Para?
Para 11, my lords.
Yes.
Offer 49, page number 49, affidavit in reply. It is said that it is further submitted that on 13 July, while visiting Jorhat for tourism, a few of cousin unexpectedly appeared at the visiting location with cake and balloons to surprise the minor child. Following his recent birthday and ceremonial event, their
So you are admitting that they,
yes, my lord, some cousin, because we are distant cousin, my lords. Some cousin had come and they had brought balloons. My lords, in their additional affidavit in opposition, they did not bring out pictures. But in my lords, in this case, my lords may kindly look to page number 103.
no, you have shown that earlier also.
Balloons. And lastly, my lords, lastly, one last submission, my lords. So, last submission, my concluding submission, my lords.
Yes.
So, assuming for a moment, my lord, we have traumatized the child. The instant reaction of the mother should be to, my lords, visit my lords, the doctor immediately. If the child had been traumatized on 13 July 2025, my lords, she should have visited, my lords, the doctor immediately at Jorhat itself. But what she does, she went to Child Welfare Committee. Because now the Child Welfare Committee sends a confidential letter to family court that let the visitation be taken over, stripped off. Now, my lords, in my humble submission, she gives an page number 123, my lords.
Yes.
Page number 123, she consults the doctor. Where, my lords? Near her house. My lords, has page number 123.
Yes.
Page number 123. So this is, my lords, on 22 July 2025. So, my lords, had it been the case that a child had been traumatized, it would be urgent duty of the mother to visit the doctor immediately. But she does not do so. Because, my lords, she prefers to visit a doctor who is a family friend in 6 Mile, because her house is also in 6 Mile. That is on 22 July 2025. Almost, my lords, 10 days after the incident. So, my lords, in my humble submission, what will be the allegation and counter allegation, my lords? If we fall back upon the law, a judicial order is still subsisting, my lords. Yes. And secondly, my lords, she has all the executive machinery at her hand. I'm a private consultant, my lords. If, my lord, if there is no interference made by this court, I have no other way to meet my child, because in her submission is this, that the child does not recognize me, in which in my CRP I have said that this is a parental alienation syndrome. And therefore, my lords, if not your lordship, then there is no other way that I can meet my child, and therefore we seek indulgence of this honorable court. And that is my humble submission, my lords.
In this contempt petition, what is your prayer?
That this, my lords, this may be resumed, my lords. 7/9/2024 may be resumed. And if the modification has to be done, that will fall back upon CRP, my lords.
Okay. Yes.
I'm sorry to say, my lord, my learned friend,
Under section 10, what is the jurisdiction of this court? What this court can do in contempt petition?
No, section 12. Section 12, my lords. Punishment for contempt.
So you're not praying for punishment.
I'm working for punishment, my lords, because it may extend to 6 months or it fine. So we say that not just implement, some exemplary cost may be imposed, because today, my lords, your lordship is not touching upon CRPIO. Because what has happened, my lords, just 2 minutes, just three things. First of all, she filed a transfer petition. When this transfer
No,
petition,
please, no repetition.
no repetition. Then she came for Khula Tala, which was violated. She always comes with such applications for which we have to come to before the court, get it quashed. She brought the CYCWC, that also we had to get it quashed. So, my lords, first of all, punishment of contempt and some exemplary cause, because the use of power and her bureaucracy and her connection is so much and so forth.
Yes, Mr.
Yes, my lords.
Yes, Mr. Sheikh.
Look here, as your lordship already pointed out, that section 10 of the Contempt of Court Act, my lord, power of High Court to punish contempts of subordinate courts. So, my lord, I am skipping this first one, my lord, provided that no High Court shall take cognizance of a contempt alleged to have been committed in respect of a court subordinate to it, where such contempt is an offence punishable under Indian Penal Code. So, my lord, here your lordship, subject to correction, my lord, I referring to section 188. 188 of the IPC.
Whether 188 would be applicable.
My lord, here it is said, my lord, whenever knowing that by an order promulgated by public servant lawfully empowered to promulgate such order, in such directed to abstain from certain act or to take certain order with certain property in possession under this management disobeyed such direction, shall, if such disobedience causes or tends to causes obstruction, annoyance, or injury, or risks obstruction, annoyance, or injury to any person lawfully employed, be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 200 rupees, or with both. So, my lord, whether the court's order will come under this, my lord, that is subject to your lordships. Because, my lord, in that case, what will happen, my lord? The punishable under Act IPC, in that case, my lord, I am to commit some contempt against the court, my lord. Then only, my lord, there will be some contempt against me, and then your lordship can take cognizance. If supposing, my lord, I disobeyed the court, I dishonored the court, in that case, my lord, that
What is your submission?
some
Whether
dishonor.
judicial orders
My lord.
will be subject to provision under section 188 IPC?
My lord.
What is your submission?
My lord, regarding this, my lord, I want to submit that actually, yes, whether it will apply to this section 10, my lord, or not.
No, that is in the form of a question.
My lord, I'm leaving to your lordship. I'm leaving to your lordship. Now your lordship, here, my lord, my learned friend, times and again use a word which is very unsuitable. that misleading. Without looking into, my lord, without looking into record properly, the word used that I am misleading the court. And he also addressed the senior friend misleading the court. Your lordship would be pleased to see page 98, my lord. Additional affidavit. Additional affidavit, page 90.
Yes. Yes.
Yes, my lord, in the top, my lord, petition number 1910 of 24. My petition is petition number 1910 of 24. How my learned friend is puzzled, my lord, and said that I am misleading the court. He is puzzled because number is same. 1910 of 2024 and his petition is of 25.
No, but his number is 1911.
19?
1911.
So how I am misleading, my lord? He said that it is his petition and I stated that it is my petition. I am misleading. Misleading word used more than once, my lord. And your lordship would be pleased to see. This is the petition. What is my prayer, my lord, in the petition before the trial court? That is at page 101. Under the above facts and circumstances, it is most respectfully prayed that your honor would be pleased to admit this petition. Call for a report from the in charge of Gormur Police Outpost, Jorhat, to ascertain if the child is willing to talk to and cooperating the petitioner further during visiting hours for the interest of justice. Till arrival of the report from in charge of Gormur Police Outpost, Jorhat, further be pleased to keep the order dated 7/9/2024 granting visitation right be abeyance and spare the child from trauma and agony that he is going through for focusing him to meet his father against his will for well-being of the child and in the interest of justice. So, my lord, my petition is dated, my lord, 25/11/2024. Much earlier, my lord.
What order was passed on this petition?
My lord, this petition is kept pending by the learned trial court. No order has been passed. This petition is pending. Thereafter, my lord, during pendency of this petition, my lord, subsequent occurrence happened. Again, my lord, I have filed, facing by that situation, my lord, I have filed another petition, my lord, that is on 23/7/2025. That is at page 82. Of my affidavit in opposition. Additional affidavit, page 82. My lord, in the top, my lord, in the left-hand side, filed on 23/7/2025. In so many words, my lord, my learned friend admitting that this petition is pending. The petition is there.
I did not admit, my lords.
So, my lord, what I earlier pointed out, my lord, if my learned friend disagree that I have not filed a petition on 23/7/2024 in Ms. J case number 153 of 2022. And I am submitting before your lordship that I have filed. And this petition is pending till date. So my lord, in that case, my lord, record of Ms. J case number 153 of 22 will be necessary. Which one is correct? Whether I filed it or not filed it.
Assuming that you have filed it, you
Yes,
make your
if
submission.
it is assumed, my lord, no problem. Now, your lordship, that earlier petition of 2024 pending. Thereafter, my lord, as the family court did not take any action, so I went to the police station with this side. Next time, my lord, again, my lord, the side faced this difficulty and filed this petition, my lord, and with documents, my lord, which has been already referred by my learned friend. And your lordship will be pleased to see the prayer at page 93. Page 93.
Yes.
Under the above circumstances, your lordship got it. Under the above circumstances, yes, therefore prayed that your honor would be pleased to admit this petition. All for records, issue notice to the opposite party to show cause as to why the order dated 7/9/2024 passed in Ms. case number so and so shall not be cancelled. And on perusal of reply to show cause, if any, and after hearing the parties would be pleased to cancel the order dated 7/9/2024 passed in Ms. case number so and so in the interest of justice. Further, it is pledged that till disposal of this petition, operation of order dated 7/9/2024 in Ms. case number so and so may be stayed ad interim ex parte in the interest of justice. Furthermore, it is prayed that your honor would be pleased to hear this petition on any date before 27/7/2025. That is the date fixed for next visit of the child by the father in pursuance of the order dated 7/9/2020 passed in the concerned case. So, my lord, this petition.
What orders were passed?
No order has been passed, no, that is pending. And in the meantime, my lord,
No, no.
contempt has been.
It might not have been decided, but the fact that you filed this petition before the court,
Only it is written on the body of the petition, the put up with record.
then whether it was put up with record or not,
It is tagged with record, my lord. That is in record.
no order has been passed.
No order has been passed. And what happened, my lord? In the meantime, this contempt has been filed, CRPIO has been filed. That enter proceeding in that guardianship case, my lord, stayed by your lordship. Further proceeding stayed. So when further proceeding is stayed, so in CRPIO, my lord, so the principals as family court cannot do anything on this petition, in the petition.
When it was stayed,
My lord,
18/9/2025, my lords.
18/9/2020.
Filing date was 18/9, my lords, and order date was, my lords, 22/9/2025. 22 September 2025, my lords, it was.
So my lord, when your lordship stayed the guardianship case, further proceeding. So principal judge cannot act upon these petitions, my lord. Either his petitions and my two petitions, my lord. He cannot do. So actually, what is this, my lord? My humble submission before your lordship, from the behavior of the petitioner, the contempt petition, he wants that everything is to be done by the High Court. Seems that he do not have any belief on the family court. That High Court will do everything. So CRPIO, so WPC. So my lord, all the proceeding is pending before Honorable Court, my lord. And your lordship, I want to humbly submit before your lordship that when my friend said that visiting hour should be 4 times on a month, that will be considered by the family court. When I'm saying that this order should be cancelled because child is not going to meet her father, his father. So in that case, my lord, entire thing within the jurisdiction of the court below. And what happened, my lord, for deciding this case, my lord? Deciding these petitions, his friend's petitions and petition of mine, my lord, two petitions. If necessary, my lord, report may be called for. I already prayed for that. So what happened? And your lordship would be pleased to see that I have annexed some documents, my lord. Child was taken to doctor. There are documents I have annexed with this petition. So, my lord, to prove this, my lord,
No, child was taken to doctor, but what was the observation?
observation is there, my lord. The doctor advised that it should be consulted with the clinical psychologist. Your lordship would be pleased to see. And what happened, my lord? My learned friend always targeted my client, my lord, that he is ACS officer, so she can do everything. What is possible on her part, my lord, she have done, because, my lord, she immediately informed the officer in charge Gormur outpost at page 106. What has happened? 106, your lordship will say. What she will do? Maybe ACS officer, but she is not above law. She is to go by this. Officer in charge, Gormur Police Outpost, Jorhat. Entire thing has been narrated. Now, your lordship, so, my lord, as your lordship aware of, if there is any difficulty regarding child, my lord, if the parents is in difficulty, threat from somebody else, it may be from her husband, father, or somebody else, my lord. In that case, there is an organization, my lord, to look after the child, minor child, 6 years. So, my lord, my client approached the chairman, Child Welfare Committee, Jorhat, on 13/7/2025. Narrated everything, my lord. Narrated everything, what has happened in Gormur Police Outpost. In detail, my lord.
13?
My lord, your lordship, page 114. It was submitted on 13/7/2025 to the chairman of Child Welfare Committee, Jorhat. Page 114. So, my lord, your lordship will turn to page 116. What the situation mother of the child is facing. 116. Therefore, sir, 116.
Yes.
Yes, my lord. Therefore, sir, I kindly and humbly request you, kindly help me and my son and protect his well-being by doing the needful. What wrong I have committed, my lord? My son is very scared and disturbed mentally. Again, it is said, I request you to help me, help him, my child. So, my lord, now what happened? After this petition, my lord, the chairman, Child Welfare Committee, take initiative. Before that, my lord, I also approached the additional superintendent of police crime on 16 July 2025. That is at page 1 on 20. 1 to 0, narrating everything that this has happened. That why I go to the additional superintendent of police crime, my lord, because my lord, the Gormur police station was the venue, meeting point of the child with father. So additional SP was informed regarding these incidents.
And you have informed the family court on 25/7,
Yes,
23/7.
yes. 23/7. After doing this, my lord, at Jorhat level, my lord, doing this, approaching this chairman, OC, Gormur outpost, then additional SP, my lord. Now your lordship will turn to page 122. It is, I approach the doctor, my lord. And
Why
doc-
guardianship case is pending in family court Guwahati?
My lord,
Guardianship case is pending because Malot's issues, the cross-examination done without framing of issues. And secondly, Malot, the additional affidavit.
No. Why it is pending before Kamrup Metro Court
Because
when the minor is in Jorhat?
Exactly, Malot. So basically, we filed it in Guwahati, Malot. Thereafter, the respondent filed a transfer petition. Then Malot, the transfer petition was disposed of. That she will now contest in Jorhat. Then she filed a divorce petition also now she filed a divorce against me in Kamrup
No.
Metro only.
no.
That
My
is not.
Filed a divorce case against me in
learned
Guwahati
friend
only.
used to parlor.
That is not my query.
My lord,
My query is very simple query. When the minor is in Jorhat,
Jorhat with her mother.
there is a legal requirement that guardianship case ought to have been filed in that place
Yes, Malot.
where normally the minor resides.
Yes, Malot.
My lord.
So why it is filed in Kamrup Metro?
I filed in Guwahati because I reside in Guwahati, Malot. Malot, I filed in Guwahati.
This plea has not been raised before the court.
My lord, what
You
happened?
have not raised.
Only one point, my lord. What happened, my lord, after filing this case, guardianship case in Guwahati, I filed a petition before your lordship stating that I am in Jorhat, child is with me, so it may be transferred to Jorhat. But your lordship declined on the point that you are serving there, not permanent resident there, so you may be transferred somewhere else. So your transfer petition.
You filed a CRP.
No, my lord, not CRP, my lord, but transfer petition.
No, it's not.
Transfer of the guardianship case to Jorhat. But your lordship observed that I am serving there. That is not my permanent resident. That is why there may be transfer, so transfer petition was not.
Well, that's a misleading submission. And I humbly submit, my lords. My lords may kindly see those orders on the basis of which, my lords, the transfer petition was dismissed. That is in CRPIO file, my lords. Such misleading submissions are given, my lords.
Oh,
My lords may
what
kindly-
misleading submission? You
My-
talking record?
Yes, my lords.
No,
May I kindly take up
don't use
CRPIO?
this word misleading.
No, my lord, may
I-
kindly take up CRPIO.
No, my friend.
Just 2 pages
Not,
of transfer
you-
petition.
it is very popular word to you.
Yes,
But
therefore
don't
I am
use this.
submitting with facts, my lords.
Misleading.
I am submitting
What
with
misleading?
facts. No, here I am submitting with facts. My lords, here, my lords, if I may read it.
Why transfer petition is not allowed? What is the ground?
Please read it, sir.
No, you see,
Please
you
read
say, you read.
Please-
Unnecessary.
Sir, please see a CRP file. Just once, sir. My lords, just once CRP file, CRPIO.
Why transfer petition is not allowed? A doctor's certificate, my lord. No, my lord, regarding this, my lord. What has been, when my interim order was vacated, my lord. So I find that I will not get suitable order from the honorable court. So that that partial mode may be allowed. That was my prayer, my lord. So in that way, that was closed. So your lordship would be pleased to see page 122, my lord. the medical, my lord. I brought the child to the medical and medical say, RB after 3 months to consult clinical psychologist later as advised. Give supportive care and advice to keep him from traumatic triggering factors as far possible.
CRPIO কোন তারিখে রাখছে?
So, under these circumstances, my lord,
Second.
my short submission before your lordship, that no question of contempt has arisen.
Okay.
Because, my lord, petition of my learned friend and petition of mine, 2 petitions, my lord, are pending before the family court. So let the family court decide whether I have committed any wrong. If the court finds that I have committed wrong, in that case, my lord, contempt will arise. Otherwise not, my lord. And in this case, my lord, my 2 petitions, my lord, it is the question of facts, my lord. It should be ascertained from the report of the outpost from chairman, Child Welfare Committee. This will be done by the family court only, my lord.
Heard Mr. M. Burman.
My lords, if I may just counter just 2 submissions. I'll not repeat any submission, my lords.
Yes.
I'll not repeat once any submission. My lords, my learned senior colleague has talked about page number, my lords, page number 98, where, my lords, he talks about 1910. My lord, page number 98, he talks about 1910. Whereas, my lords, in page number, my lords, 21 of his affidavit in opposition, he himself writes that he has filed 1911. This is a factual aspect. There is nothing to be decided on, my lords, who is misleading or not. That's a factual aspect. It will, my lords, clearly prima facie on the record who is misleading. Second thing, my lords, there is a pertinent, my lords, submission made by my learned senior colleague that I always want to go to the High Court. My lords, what is the next forum that I can visit? Lastly, my lords, the respondent always wants, my lords, CWC to interfere, the additional superintendent of police to interfere, my lords, the DSP, everyone to interfere who is in the executive body. My lords, why did not they file the CRP? We filed the CRP, my lords, was on 22/9/2025.
Okay.
Yes, my lord.
Okay. Heard Mr.
M. Burman, my lord.
M. Burman,
My lord,
learned
only one thing, my lord.
learned
What
counsel
happened,
for
my
the
lord?
petitioner.
CWC.
Also heard
CWC,
Mr. M. S. Haik, learned. Yes.
1 minute.
You cannot continue forever.
My lord, only one point. CWC, my lord, CWC is blocked by filing writ petition. Every forum will be blocked by him. My learned friend.
Hearing concluded. Order reserved. Now, let this case be listed for delivery of orders on Monday, 2nd of March. In contempt petition, I'll pass final orders on 2nd of March.
2nd of March.
On that day, CRP is listed for hearing.
2nd of March.
Yes.
My lord.
I'm so grateful, my lords, for patient hearing, my lords.
Separate listing.
I asked for prolongation of delay. The delay is 378 days. The regarding
Notice-
service last occasion paper was published into one is vernacular, one is national paper, Times of India. I have filed additional affidavit before your lordship regarding steps taken upon the respondent.
regarding respondent 1, 2, 3, 6 and 8. 1, 2, 3, 5, 6 and 8.
5 is not there. 1, 2, 3, 6 and 8. Heard Mr. L.K. Bora, learned counsel for the applicant. On perusal of the office note dated 21/1/2026, it appears that the applicant has filed an affidavit in compliance of issuing notice upon respondent number 1, 2, 3, 6 and 8 by way of paper publication. In two newspapers, namely, what are the newspapers?
Protidin, Okhomia Protidin and Times of India.
Ohomia Pratidin dated
Dated 11/12/2021.
11/12/2025, 25, as well as Times of India dated
Same day.
of the same day. The date of appearance mentioned in the notice published in the newspaper is, what was the date of appearance?
My lord. In 26 January 2026.
26 January 2026.
Sorry. 28.
28 January 2026, that is today. Considering the affidavit filed by the applicant as well as after perusal of the newspaper annexed therewith, it is hereby held that the notices issued to respondent number 1, 2, 3, 6 and 8 are duly served by substituted. We are giving one more date for hearing. Let this matter be listed,
Thought that may be given, but execution proceeding is going on.
listed for hearing. Again, let this case be again listed for hearing of the interlocutory application in the orders column on 13th of February. Shorter, Arukum, 4th of February.
Yes. Masulaj.
Notice was issued in this.
You have filed written objection.
Not filed a reply because of the fact that let my learned friend first satisfy your lordship as regards the maintainability of this application. Because otherwise, my lord, filing of a reply to this long petition, because what is this application, your lordship will see the cost title, the page number 1. This is an application under order 39 rule 2A.
Not
Application-
related with section 151.
151
For
will come later.
exertion,
Now-
enforcement of
Now,
petitioner's
what-
order.
yes, he is
Not-
filing an
Not
application.
for punishment.
So that is, let him satisfy that this application which he has made, that is in consonance with the prayer which he is seeking. So I crave your lordship indulgence. If maintainability your lordship is satisfied, we will file a reply back. He has filed his application under order to 39 rule 2A. He is seeking enforcement of the order which was passed initial at the stage of the suit, my lord. While the suit, my lord, was filed and
Then hearing may be
injunction
fixed
was,
later.
injunction order was passed, now.
Hearing may be fixed in this.
The hearing, if this maintainability is satisfied, my lord,
That
I
is-
will
that is
crave
why
my lords
hearing-
to file
hearing is necessary in this case.
file a detailed reply, my lord.
You have sought injunction.
Yes, he is seeking injunction. He is also seeking, my lord, enforcement of an order that your lordship will pay, see at page 17. And which is this order? Initially, when we file a suit, my lord, along with the suit, we file an injunction application. And this is this order, this 5/4/2008.
Paragraph 12, 13, 16, my lord, I have clearly stated plaintiff was in continuous position. Position was delivered to the plaintiff and issue number 2 decide in this in favor of the plaintiff that he was always in position and
For my lord,
cultivating the
specific
land.
performance. It is a,
So
we are cultivating the land.
clear
Now,
issue also there, two judgment, concurrent judgment passed, holding that plaintiff is in position. So finding position, the Honorable Guwahati High Court also issued last page 22, my lord, annexer. Last order, under the circumstances, page 22, my lord. This annexer 2, under the circumstances, this court for the instance of justice.
You may file a written objection raising the plea of maintainability therein. If it is, if you are saying that it is not maintainable.
His lordship is well aware, my lord, I need not apply.
That's why he
My lord.
afraid to file any objection, so that they have no objection, the hearing will be fixed, my lord. I will satisfy the honorable court. This was maintained.
My lord, he is
No,
coming.
no,
with
he is
his-
ready for hearing
I
today.
am ready for hearing today. Let him argue. It is his case.
So the hearing, not necessary today for.
Why it
because
is his
I have
case,
to-
he knows everything.
Today is not fixed for hearing, because it was, for the other
No,
side, opportunity was given. to
When a
file.
IA, my
Objection.
learned friend is not
If
aware,
no
when IA
objection,
is
then I
filed,
have no matter.
hearing for
Immediate
IA will come in
hearing
orders
will be
column
fixed
only.
on a day of the convenient date, yeah.
Hearing for IA will always come in orders
Okay,
column.
you try, you file and written objection.
We will-
Let it heard.
Be Hussain.
Mr. B. Hussain, learned counsel for the applicant. Also heard Mr. A. Das, learned counsel for, how many respondents are there?
Opposite parties, already 10 opposite.
Learned counsel for the opposite parties. Learned counsel for the opposite party submits that the present interlocutory application, the instant interlocutory application in its present form is not maintainable, and therefore raises a question of maintainability of the instant interlocutory application. He submits that the question of maintainability may be heard first, and if required, he may be allowed to file a written objection thereafter.
My lord, is it necessary a simple hearing may be fixed? I'll satisfy order may be passed on that.
On the other hand,
It is not a civil.
learned
case, my lord,
counsel
that
for the
Many
applicant
issues not necessary.
submits that another date may be fixed for hearing of the instant interlocutory application. Considering the submissions made by learned counsel for both sides, the applicant is allowed to file a written objection, is allowed some more time for filing written objection.
Opposite party.
No, the opposite party is allowed to file some more time for filing written objection, in which he may take his plea of maintainability of the instant interlocutory application. Let this matter be listed again on 13th of February.
Let it be, my lord, after 19th, my lord.
After 19th.
25th.
24th of February.
Item 45.
The connected second appeal has been admitted. This IA, my lords, unfortunately, the order of your lordship has not been uploaded, my lords. We could not take step on regarding this IA. But in the main RSA, which is, I think the file is also available. My lord, that, in that matter, we have taken the steps to respond.
No, if you fail to take step, then the interim order would be vacated.
My lord, the order is not uploaded yet. That is the difficulty.
This order has not.
Yes. That is why we could not place it before the learned executing court also. We have only placed the order in the RSM. Perhaps some technical issue may be there.
Itu-
I'm not aware. Even today I have checked, my lord, personally.
Abhishek of Kobo with this, to upload this order. Heard Mr. A. Ganguly, learned counsel for the applicants, who submits that the applicant could not take steps for issuance of notice on the opposite parties as the order dated 15/12/2025 is not yet uploaded in the website of the Guwahati High Court. Stop. The courtmaster is directed to do the, who will upload it? Right. আপনি inform করিব। Right. To do the needful for getting the aforesaid order uploaded immediately. The applicant shall thereafter, within 7 days, take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days there. 7 days returnable on 26th February. The interim order granted earlier shall continue till next date.
Good. In the main RSA, we have taken steps.
Okay. RSA. Heard Mr. A. Ganguly, learned counsel for the appellants. The notice issued to the respondent has not yet returned. The registry is directed to place the track consignment report of the notice issued to respondent by speed post, before this court on the next date fixed. The registry shall also issue a reminder for calling for records of the trial court as well as the first appellate court list on 26th February.
Item 36.
May please your lordship, there is a continuation of delay of 71 days.
Will issue notice.
Your lordship.
Heard Miss, what is your name?
P. Bordoloi.
P.
Bordoloi.
P. Bordoloi, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 has been filed by the applicants, praying for condonation of delay of 71 days in filing the connected MAC appeal, whereby the applicant has impugned the judgment and judgment dated 7/7/2025 passed by the Motor Accident Claims Tribunal, Sonitpur, Assam in MAC case number 33/2024 within bracket death. Stop. Let the notice be issued to the respondents. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 23rd February.
All right.
Item 37.
There is a continuous delay of 64 days, Your Lordship.
Same order,
Notice movement.
same order, impugn order to file over here. Same date,
It's an injury. This one is injury.
Okay.
All right.
same order. Here, asylum.
Item 38.
May I please, Your Lordship, my lord, there is a delay of 55 days in filing the connected.
Pardon, miss, what is your name?
And Sodhuri,
M.
and Sodhuri.
N. Chaudhary, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 has been filed by the applicant Sebul Hussain Laskar alias Sabul, praying for condonation of 55 days in filing the connected MAC appeal, whereby the judgment dated 1/4/2025 passed by the Motor Accident Claims Tribunal Kachar, Silchar in MSC case number 452/2018 has been impugned. Issue notice to the respondents. The applicants shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 23rd February.
Item 49.
May it be Your Lordship. Your Lordship takes up interlocutory application number 76 of 2026. With a delay of 630 days, Your Lordship. In a similar
630
days, Your Lordship.
Okay,
In a similar petition, Your Lordship provided a pass an order, Your Lordship. I'd like to place the order.
who is the respondent number 1?
The claimant, Your Lordship.
Who are you?
I'm the National Law University, Your Lordship, the applicant and Judicial Academy.
Notice will go.
Yes, Your Lordship. In a similar order, Your Lordship also state the money execution, Your Lordship. Your Lordship finds at page 60 of the interlocutory application.
Why have you approached so belatedly and then praying for stay of execution?
Your Lordship, this procedural lapse, Your Lordship.
For lapse, you,
Because we are also not made parties before the proceedings, Your Lordship. And it was not made known only when we received the money execution notice. Then only it came to a knowledge.
when have you received notice of money execution?
If Your Lordship peruses page 60 of the interlocutory application, Lordship. This is passed on 26th of August 2025.
So thereafter also you have
Yes,
lapsed.
Your Lordship, we have applied the certified copies and there is delay in providing certified copies, Your Lordship.
Lord Mr. A. Das, learned counsel for the applicant. Also heard Mr. T. R. Gogoi,
Lordship.
learned senior,
3, Lordship.
learned government advocate, appearing for respondent number 2 and 3.
Lordship.
This application under proviso to section 74 of the right to fair compensation and transparency in land acquisition, rehabilitation, and Resettlement Act 2013, read with section 5 of the Limitation Act, has been filed by the applicant, National Law University and Judicial Academy, Assam, praying for condonation of delay of 630
Your Lordship.
days in filing the connected land acquisition appeal. issue notice. Since Mr. T.R. Gogoi, learned government advocate, has appeared for the respondent number 2 and 3, no formal notice need to be issued against the said respondent. However, as regards the respondent number 1 is concerned, the applicant shall take steps for issuance of notice upon the said respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 23rd February 2025. Learned counsel for the applicant has submitted that in the meanwhile, as the decree holder, namely respondent number 1, has already filed an execution case bearing execution case number
34 of 2025.
34 of 2025, which is pending before the court of
Additional District Judge Amingaon Kamrup.
an additional district judge Amingaon Kamrup
At Amingaon.
at Amingaon, same may be stayed. He further submits that unless the execution of decree is stayed, the applicant would be highly prejudiced as the execution of decree has in the execution of decree there is a probability that the accounts of the applicant National Law University and Judicial Academy may be frozen. Stop. Then quote para 6. Quote para 6 from this Yatet Vedim list accordingly.
Money execution will be 34. of
Money
2025.
execution case number 6 or
4 of 2025.
12 or Jagat 34 of 2025.
In reference to LA reference case number 13 of 18.
Not necessary.
Yes, as your lordship, please. Your lordship has quoted the paragraph 6 of the previous order, your lordship. Much obliged, your lordship. Obliged.
Item 40.
Lordship, this matter may be tagged along with the order provided, lordship. IA number 3337 of 2000.
Let this matter be listed along with
IA civil.
IS within bracket civil number
3337
337
of 2025.
of 2025.
Much obliged, your lordship. Obliged.
Item number.
Lordship, we have filed the side for condoning the delay of 15 days and preferring the
Will
settlement.
issue notice.
Yes, Lordship.
Heard Miss M. Sakya, learned counsel for the applicant insurance company. This application under section 5 of the Limitation Act 1963 has been filed by the insurance company applicant for condonation of delay of 15 days in filing the connected MSC appeal, whereby the applicant has impugned the judgment and award dated 27/8/2025 passed in MSC case number 316/2019 by the Motor Accident Claims Tribunal, Kamrup Amingaon. Kamrup, Amingaon. Issue notice to the respondent. The applicant shall take steps for issuance of notice by speed post as well as by the usual mode within 7 days from the date of this order. Returnable.
We would also like to take step through Dusty upon respondent number 1. Speed post usual and Dusty, Lordship, because the Baki side proceeding has been initiated in this case.
Speed post as well as usual mode within 7 days from the date of this order. Returnable on 24th February. The applicant is also allowed to take steps additionally by way of Dasti on respondent number 1. Stop. In the event the notice issued through Dasti mode is served, the petitioner shall submit an affidavit of compliance before this court on the next date fixed.
Lordship, as a date prior to 20th February may be allotted, Lordship, because
13th February.
obliged, Lordship.
41.
May please your lordship. This I have for condemnation of delay of 46 day, lordship.
What is your name?
P. Sutia.
Heard Ms. P. Sutia, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant insurance company praying for condonation of delay of 46 days in preferring the connected MAC appeal, whereby the judgment and order dated 18/7/2025 passed by the Learned Commissioner Employees Compensation, Borpeta in EC case number 44/2024 is impugned. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th February.
Item 42.
Right, please, your lordship. In this case, appellant number 1 died and the petition is within time, lordship.
My lord, I appear for the respondents. I have been newly engaged. I filed my wakalatnama today, my lord.
Regarding substitution petition, any objection?
No objection, my lord.
Heard Ms. R. Chaudhary, learned counsel for the applicant.
A. Khan.
Heard Ms. R. Chaudhary, learned counsel for the applicant. Also heard Mr. A. Khan, appearing for respondent number
1.1 and 1.2.
Respondent number 1.1 and 1.2. Learned, this interlocutory application has been filed under Order 22, Rule 3 of the Code of Civil Procedure 1908, paying for substitution of the legal heirs of appellant number 1 in connected regular second appeal number 322/2017. Learned counsel for the applicants has submitted that in the connected regular second appeal, the appellant number 1 had died on 1/11/2025, leaving behind 6 legal heirs as mentioned in paragraph number 3 of this application. She submits that the substitution application has been filed within the prescribed period of limitation and therefore prays for allowing the aforesaid substitution. Mr. A. Khan, learned counsel for the respondent, does not raise any objection. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the record materials available on record. Since this application has been filed within the period of limitation for substituting the legal heirs of deceased respondent, deceased appellant number 1, and since same has not been objected to, it is allowed. The names of Yatun Nesa, Rupa Begum, Rupa Mali, Yar Hussain, Iqbal Hussain, Rubina Khatun.
Yaqub Hussain.
Paragraph number 3, Sabu. Yar Hussain, Yaqub Hussain, and Rubina Khatun be substituted as the appellant number 1.1, 1.2, 1.3, 1.4, 1.5, and 1.6 respectively in place of the deceased appellant number 1, namely, who died?
Ismail Hussain. Lordship.
Namely Ismail Hussain alias Ismail Ali alias Putu. This interlocutory application is accordingly disposed of. The appellant is directed to file amended cause title in the amended cause title in the memo of appeal in the connected RSA number. What is the RSA number 320?
322/2017.
322/2007. Within 7 days of the date of this order. Place this matter again on 26th February.
Obliged.
My lord, I have a small prayer, my lord. My lord, respondent numbers 1.1, 1.2, there is spelling mistake in the name. So that needs to be rectified. So should I find
Is that in the amended cost title, I will rectify.
Learned counsel for the respondent number 1 has submitted that, Putul has submitted that in the memo of appeal, the spelling of the names of respondent number 1.1 and 1.12 are wrong. Instead of Mehnaz Manwar, it ought to have been
Mahenaz, MAHENAAZ,
Mahenaz Manwar. And instead of Shahnaz Manwar,
SHAHNAZ.
it ought to have been Shahnaz Manwar. Spelling to side logo.
Lordship.
Learned counsel for the appellant / applicant submits that she may be allowed to rectify the same in the amended cause title. The prayer is allowed. List accordingly.
Bless my lord.
Item 44 and 45.
এই দুটার নাম উকিলৰ পৰা লৈ ল'ব।
May I please, Lordship.
44 and
My lord, in this case, my lord, item number 44 and 45 are related same accident, my lord, and negligence of driver of 2 vehicles, my lord. One is truck and other is auto, my lord. And my lord, and already admitted in item number 45, my lord, we have already deposited 50%, my lord. And in
why it has come in orders column?
But in
I
item
don't know, my lord,
40,
they have,
mention was made by some other council, he is out of session today due to some personal difficulty. I am appearing on behalf of him. And secondly, my lord, in 473 MSC appeal number, lordship, 50% was not deposited.
actually,
Not deposited.
my lord, I'm
No, let us come one by
Something,
one.
my lord. Actually, my lord, truck was never installed by our company, my lord, never, my lord. It is, we have already filed, my lord, IA 1485 written objection, my lord. It may be heard with hearing, my lord. TCR already come, my lord. And driver was not.
Why this was listed today?
They have mention was made, therefore, lordship. Mr.
Otherwise, it is ready for hearing.
Ready for hearing, my lord.
470, ready for hearing? My
Yes, my lord.
What cases?
471, my lord.
471 already they have taken money, my lord.
And
Then
for-
ready, my lord, already.
73,
But in 473, my lord, 50% amount was not deposited.
but it is ready for hearing.
Hearing, my lord, yes, my lord.
Lordship.
We'll hear it. Heard
Fixed.
Miss L. Devi. London, L. Devi,
El Sarma.
sorry. Heard Miss L. Sharma, Learned counsel for the
Appellant, my lord.
Appellant Insurance Company. Also heard Mr.
H.J. Tamale on behalf of
H.
Purva.
J. Tamuli appearing on behalf of Mr. R. Barua. learned counsel for the appellant, learned counsel for the claimant respondent.
Claimant respondent.
It appears that
My lord, kindly, IA number 1893. We are not pressing, my lord. It may be disposed of, my lord.
Yeah.
what happened to MSc
My lord,
473/2?
both are, my lord, same ground, my lord, on both the cases, my lord. Because we are not liable at all, my lord, in 473, my lord. Driver have not valid driving license, and my lord, we have already explained in written objection, my lord, 1485/2022, my lord. It may be heard with all together with hearing time, my lord.
Which you are not pressing?
1893. Stay petition, my lord, in MSc appeal number 473, my lord.
1893.
Yes, my lord.
1893. IA 1893. Heard Miss L. Sharma, learned counsel for the applicant. Also heard Mr.
H.J. Tamoli.
S.J. Tamoli, learned counsel appearing on behalf of the claimant respondent. Learned counsel for the applicant has submitted that the applicants are not pressing the instant interlocutory application. Hence, same may be disposed of. Stop. The prayer is allowed. This interlocutory application is disposed of on not being pressed. Aru.
Not being pressed.
Like hearing about it, yes.
In MSc Appeal 471,
Yes, my lord. In here, my lord, IA 1485 may be heard with hearing at the hearing time, my lord. It is our written objection, my lord. Because truck was not insured with us, my lord.
whether records are there.
Yes, my lord.
This is, both the appeals are arising out of a common
Same
case.
accident, my lord.
Why two appeals?
Two appeals, my lord, they different, my lord, award is passed by tribunal. One award is passed 81,700. In MSc case number 203, my lord, they have already in tribunal, they have filed two different cases, my lord. That's why, my lord. And in one rupees 1,93,180 is awarded in 204. So both are both may be heard, my lord, altogether.
No, the appellants are and respondents are same
Yes, my lord.
in both the cases. You are saying that accident is also one.
Yes, my lord.
Then why two cases?
In the tribunal, my lord, same name, my lord. I think, my lord. I have no.
Two judgment.
Two separate judgments.
It is my senior's brief, my lord. That's why, my lord, I am not.
3 and 2.
Going.
203 of 2006 and Sonali Soy.
Two zero three, 204.
No complete file. No, complete.
There is a review order also.
Yes, my lord.
Review or has lordship review has already dismissed.
Dispose of a,
Disposed of.
Review of what?
delay condonation, my lord.
No, no,
I
my
think delay condonation, my lord.
already there was an order by honorable lordship that to award to withdraw the amount. Insurance has filed an objection.
Acha review, my lord. I
Yeah.
notify.
After that, review was
Depositing, my lord.
disposed of by
Up-
directing 50% to deposit 50% amount. But in one case, they have deposited 50%, but another
There is order of
473,
only 471, my lord. That's why, my lord.
they have not deposited till today. In 471, they have deposited.
No,
lordship.
but there is no order passed in appeal.
In 473, yes.
In appeal.
85 already dismissed.
How many respondents are there?
5, my
Whether notice on all respondents have?
my lord, they have claimant side already appeared, my lord, and owner, there are 2 owners, my lord. We have already paper publication is held, my lord. Already we have published in
But nothing is.
2019, my lord. I think 2019. There was an order, my lord.
Ramesh. A 3006 Dioxin.
There is an order, my lord.
Order where?
ना हमके लिखा नहीं कि तो पब्लिक पोजीशन
What is the order passed in MSc appeal?
Last order.
Yes. Whether appeal has been admitted or not.
If it has already been, last order was admitted, my lord. Lord, like,
Which order? প্রথমে আরো কি আইয়ে আছে সব আইয়ে দিয়েছো এটা
Admittedly 9 ये करना
review.
my lord, date, my lord, 21/4/23, admitted, my lord. Order dated
Where it was passed in which case?
in 471/2018, my lord.
$21?
21/4/2023, my lord.
Yes, there is no order regarding admission.
Yes, my direct deposit,
It
depositing
only deals with the deposit of money.
after admitted, my lord.
Where is the admission?
Mr. Burag Gohain, learned counsel for the appellant, my lord, come to on 3/8/2018, the court ordered that the
Subject to
appeal is
payment.
admitted, my lord.
Okay. Then notice to the respondents.
My lord, thereafter, I think, my lord. And claimant is already appeared, my lord. That's why, my lord. For the appellant, review petition.
No, you have to take steps.
My lord, paper, already we have taken paper publication, I think, my lord.
Then records are not properly maintained. There is no indication.
Yes, my lord. We check out by the ST, my lord. And driver are not necessary party, that's why, my lord. They may be deleted, my lord.
Heard Miss L. 471 RO 473, MAC 471, 473, separate orders. Heard Miss L. Sharma, learned counsel for the appellant insurance company. Also heard Mr.
H.J. Tamuli, my lord.
H.J. Tamuli,
Tamuli.
learned counsel for claimant respondent. It is submitted by learned counsel for both sides that this case is ready for hearing.
Yes, ma'am.
The records of the Motor Accident Claims Tribunal are also
Received, my lord.
have also been received. Let this matter be listed for in the hearing column
As usual.
on 12th of March,
Obliged.
Obliged, my lord.
both cases.
Viva. Viva. Viva.